be able to standardize our costs and make it easier for the small mine operators. Um, just for clarification, bonds are not fees. After reclamation, operators always get their bond back from the division for the show of the work done. With all this, the board establishes the per acre bond amounts every year, and we are doing the board. And we want to make sure that we do this so that the public has the opportunity for public comment.
Okay. So this is the, excuse me for being late. I had an urgent call of nature. Uh,
And to be clear, for the record, this is Wayne Western on behalf of the division.
Okay. So as we've gone over, the board has established the per acre costs, and the division does a presentation. And we do have the opportunity for the public to comment, because I know that this is a very important issue for many people. And this is the 10th year anniversary of when we've been doing the presentation. And so last year, we added a per acre bond amount for the 15 or the 11 to 15 and then the 16 to 20 acres, because the definition for a small mine had expanded from 10 acres to 20. And this year, what we want to do is introduce the concept of a mini mine bond. This is for very small operators that want to go out basically for hobby mining. That we have a few where you have some small gold mines where people just come in recreationally, or you have some small operations where people just want to go in, collect a small amount of stone. We have one operation where they want to come in, collect stone to build chess sets. So there is some mechanical work that gets done, but it's very minimal. And we've been tried to work with the BLM on getting the bonds reduced. And so we just want to have a mechanism for these very small hobbyist operations. Next. Okay, so when it comes to small mines, we have your direct costs, which are fairly standard. You got your earthwork, vegetation, closing any mine openings, hole pluggings, and surface facilities that would have to be removed. We have our indirect costs, which are fairly standard. They're similar to what we have in our large mines. They're the mob, demob, and for many small operations, this can be a major factor. In some cases, the cost of getting a machine out to an operation can be half of what it is. We have contingencies because no matter how hard you plan, things don't always go according to what you thought it was. Anybody that's ever done any home remodeling will know that no matter how hard you look at something, you're going to encounter some unexpected items whenever you pull up the linoleum or, you know, take down the wallpaper. We have engineering redesign. This is because in some cases, what has been planned may not always match up with what's on the ground. Main office expense to cover our costs in the for over, of managing the project. So these are things that we have, and we also have escalation. So contingency is pretty standard, 10% engineering redesign, 2.5, main office expense, 6.8, and project management 2.5. So for this, we have a indirect cost 21.8%, which has been standard over the past 10 years. And then we handle mob, demob as separate line items because, as I mentioned before, for very small operations, they can be very costly to bring a piece of equipment in. The equipment that we have used is Equipment Watch, Blue Book, which is pretty much net industrial standards. We also have RS Means, and then we base our cost calculations on the coal programs Tech Directive 7, which has been past 25 years and has been overseen by the Office of Surface Mining. And we have escalation that is based on the RS Means Historical Cost Index from the previous 5 years. This year, it's going to be a major jump. It's up to 4.64%. Last year, it was 2.7. We do allow people to, in small mines, to escalate either for a 3 or 5 year. In large mines, it's generally a 5-year situation. And for expiration, we escalate for a year out. Given the current inflation rate going up, it's not only going to be going up this year, but you'll probably see a big jump next year. Okay. Okay, so as I mentioned before, we want to get into 5 different categories. The mini mine, mines up to 5, 10, 15, and 20. They'll be based on a model mine, which we tweak for each of the categories. We do use the equipment and productivity rates that we find in our large mines that are under 50 acres of disturbance. And so we try and make the model mines as realistic as possible. And I'll turn the time over to Kim.
So
Kim,
for
I'm sorry.
yes.
The one thing we didn't ask you to do is introduce yourself.
Oh, I apologize. I was waiting for Wayne to introduce myself. So my name is Kim Coburn. I'm one of the inspectors and leads in the minerals program. I'm an engineer by training. I've been with the division now for 4 years. I still seem like the new kid on the block compared to Wade. How long have you been here?
30.
30? I'm like, that's longer than I've been alive.
And then Wayne, your position with the division now?
I am the minerals manager.
Okay, thank you. Just wanted to get all that on the record.
Wayne got promoted last year after Paul Baker retired. Wonderful. So I've been helping Wayne out on a lot on the different engineering since he got promoted, which is why I'm here. And I want to talk about some of these different mine models that we're using to be able to develop these bases for the small mine per acre bond costs. The one that we are introducing this year that we're excited about is the mini bond that Wayne went over slightly earlier. This is meant for the hobbyists. This is equipment that you can go down to Home Depot and rent, put on the back of a trailer and take out to a site. It's meant to be work that's done in a day or two. It's meant for equipment that you can reach with that Home Depot equipment. So it goes down to a maximum depth of 10 feet, can only be 2 acres tops because that includes like the roads going up to it. It's stuff that the regular operators can be able to do. And we've added that to our different mine categories. For our next category, for the 5 acre, that's when you get to bigger equipment. This is when you have to go to Wheeler and rent. So this is for the 5 acre mine goes up to about a week's worth of work of being out there with the excavator full time, reclaiming the different mine sites. These mine costs are meant so that they don't have any surface facilities, you don't have any skill houses or anything like that. You don't have chemical processes like leach pads. These are just meant for the work that's on the ground. When you get up to 10 acres, we add in a second piece of equipment. So we're adding in a dozer as well to those costs. So different types of reclamation have different efficiencies. So we see dozers be able to push away some of the dumps. And that's when you start to get into this category. The 15 acre bond cost is when you start getting a little bit more efficient by being able to have a truck that's on site to be able to move the different stockpiles. Um, Instead of just having a cat just kind of pulling and moving things around or a dozer pushing, we get a little bit better efficiencies by adding in articulated haul truck for our 15 acre. And when you get up to 20 acres, that's when you get a loader that's a little bit more efficient at loading the haul truck than the excavator. Um, this is when you start getting about a month's worth of work to be able to reclaim a mine site. Again, all these different mine models, they don't have surface facilities or heap leach pads. Those are always added on as separate costs. And with these different types of equipment and money, we have different bond amounts that are associated with them. We've updated them for the different types of models, such as when you have longer distances, you have better efficiencies, you have different laborers to be able to move around site, you have a pickup truck for different types of transports when you get to larger mines. With the different types of pickup trucks, one of the other things that we do is we evaluate haul distances. You'll see in our per acre bond costs that if you're closer to town, like Salt Lake, it's going to be cheaper. If you're farther away in the West Desert, that's going to take more time. Wayne was describing that some of these places can take a while to get to. When you get out into these areas, it can really add on a lot of time to these. So those are also captured in our mobilization. With the heavier equipment that is being brought out to site, you typically need a pilot car as well, and that also adds on costs to the small mine per acre costs. With the different line items that we add for our costs, we have portals at $2,000 and shafts at $3,000. So this is just meant for typical excavator work to be able to plug those up. We go and meet with our abandoned mines team on that, but we typically do a lot of specific site specific ones for anything that's outside the ordinary, anything that's out of the ordinary for the high walls. So we add in the demolition as separate line items depending on what the operator wants to bring on site. We also have costs that are associated with areas that they have reclaimed. So if they have like 1 acre of high wall left and then they're left with a couple areas that they've already cleaned up while we're waiting on seed, that's $500. But if they have reclaimed the entire mine site, that's about $1,000 an acre. So amount of money to get that equipment out there and still be able to roughen and seed the different areas. And the moment you guys have been waiting for, well, how much costs have gone up and what our current costs are. For mini bonds, we are proposing $4,100 for the first acre for the 1 year, and then $4,700 for the 3, and $5,100 for the 5 year. So what we were seeing is for escalation, you're dealing with a couple $100 increase per the acre. For the different costs. Just be able to go out there, get the equipment out there for a day. That's about the cost that we're seeing. For exploration projects, the costs have gone up from last year is $7,900. Now it's $8,700 for that first acre. Then each additional acre from there is $5,700. So you see the mobilization is always accounted for in that first acre, and just to get the equipment out there. And because the equipment's out there, we assume you can get the equipment off, so you don't have to account for that the second time. That's why the additional acres are always so much lower. But we bother exploration projects every single year so that we are able to keep up with what they're doing on the ground. Exploration projects typically change fairly often. With these costs, we go through and update it every year, where when we get to the small mining category, we evaluate it on a 3 or 5 year basis. Where up to 5 acres, we're seeing the cost of increase from last year, where for 1 acre of disturbance, we're looking at about 10,400 for the 5 year. And when you go all the way up to 5 acres, for the 3 year, we're looking around 3,400, 34,300 and 37,200 for the 5 year. So bringing on that second piece of equipment for the dozer, we're seeing an increase in per acre costs, where the costs have gone up to 8,100 and 8,900 for the 5 year. So our total small mine cost for the 10 acre has gone up to 79,500 and 86,800. For the 11 to 15 acre mine, we've seen an increase again in the per acre cost because we're bringing in that third piece of equipment, going up to 9,400 per acre or 10,300 for the 5 year. For the 15 acre small mine, we're seeing totals. We're estimating around 134,900 and 147,500. To go up to, this is the last part of our 20 acre bond cost sees the most significant increase because it is the largest area and you're getting a different acres. We're seeing around 10,900 for each earthwork acre for our small mines for 3 years and 11,900 for the 5 years, which is a large jump from last year. To go all the way up to 20 acres of disturbance, we're estimating that this will take about 200,600 for the 3 year and 219,300 for the 5 year. Last year we had the 5 year escalation at 175,000, so that was a huge jump for us due to increased equipment costs, fuel costs, escalation. We have increased wages. We're seeing a huge increase in these costs this year. But our methods remain the same. What we have is a reference spreadsheet. We go through and update the cost. So with the cost upgraded from $83 to $87 in labor, that's what we updated. With the cost for the equipment went from $260 to $280, we've added that in. We're still keeping the same methodology, but they have increased significantly from 2021, and we're expecting an even larger increase for next year. The way how our escalation works is we grab every July for the year. So next year we're going to see even more of an increase, but we're hoping that levels out in the next couple of years. So as we go through these different bond costs, we recommend that the board to approve the per acre amounts presented, and as we propose it for the 2022 numbers, that will take mines for exploration to 2023, or the small mines to 2025 or 2027. So I would like to open up for questions about some of our methodologies, and we'll kind of go from there.
Thank you. Board members, questions? Mr. Borden?
I ask this every year, but have there been any examples of small mines that have been reclaimed over the last year that you can use to compare to these costs as kind of a ground truthing mechanism?
We do that every year. So we go through our forfeitures. A lot of times when people are reclaiming, I ask them how much time they spent out here. For example, like a demo cost, like we would add like $20,000 for all the equipment someone had on site. And they're like, well, that took me a week to get off. And I'm like, yeah, that's what the $20,000 was for. We go through and evaluate all the different mines. We just had a mine that was called the Gem Mine that was about 11 acres, and it legitimately cost about $95,000 to clean up. So this is the 3 year escalation in here, but that's what it costs today. That's what it cost in January 2 months ago to reclaim. They've been lining up fairly well. This is an average of all those different models. We go and take the different ones. We try to take the average. Some mines are going to be under bonded. Some mines are going to be above it, but this gets us in the right ballpark.
Great. I'm happy to hear there's some ground truthing to this as well.
Yes, we ask everyone every year because we're looking for ways to save money. And that's one of the reasons why we're going to what are the different models and going, okay, let's introduce the mini mine bot. We're trying to ground truth it, trying to make more appropriate models for each of these different scenarios that we run across.
Just to be clear, the examples that you just related to us were from operators who are reclaiming their own mines. Have you had any that the division has had to reclaim and compared those costs?
Yes. So last January, I reclaimed a mine that was known as Highland Mist. It went before the board in 2020. So that one, I had a $50,000 bond for. They were going to disturb up to 10 acres. They failed. They went bankrupt, and they only disturbed 5 acres. And the cost to reclaim it was about $20,000. It took about a week's worth of work to reclaim all the different areas. they still had a whole bunch of stockpiles, and we gave those stockpiles over to UDOT to line the roads with. So we were able to save some money there. But we ground truth and go, okay, if this high wall is like 2 acres, what would it cost to reclaim? And we go and we try to model it and see what's happening.
Great. Thank you. Board members, any other questions, concerns? Yes, Mr. Church.
How have you arrived at the contingency cost percentage? Does that seem to be historically something that covers contingency?
That has historically, we've been using that because that was based on the contingencies used by the coal program that were evaluated by the Office of Surface Mining. So they have, when they have evaluated their operations, they've determined about 10% contingency is what is needed. And the overall bond numbers seem to line up fairly well with our reclamation. We usually come in about what the reclamation bond is for. So in historic terms, we seem to be getting pretty good numbers off of these model mines.
Thank you.
Thank you. I did have a question. I'm not sure I want to ask it. So, so essentially, you're asking the board to approve the new figures that for the bonding of small mines. Has there been any discussion with any members of the public who are trying to get a permit for a mine and submit a bond? Have you had any feedback on these new numbers yet? In discussion saying, hey, this year it's going to be this much?
We've just calculated these out in the past month, but we have been talking to people and letting them know that the costs are going up. And of course, this is a major factor in any economics of the mine, is because you have to put up the bond beforehand, and people are, they realize that the bond has to go up. They do realize the costs have gone up, and I think there is, a little bit of concern that these costs, are going to have some impact on mining operations.
Yeah, I can appreciate that. Hold on. I'm sorry. Go ahead.
I was going to say, I've had a lot of operators that I've locked into the 2021 rates for 5 years before this came out. I'm like, hey, we have new rates coming. And they're hoping that by going to the 5-year, this is based off of like the 2% inflation, that the inflation right now is really high. We're hoping it goes back down, so it goes back to a more reasonable rate, so that when they have the increase in 2026, that way it won't be quite as drastic as it is right now. To be able, right now, the way how we're projecting inflation is just, we're taking that 4% and using it for the next 5 years. So we're hoping it goes back down, so there'll be less costs.
Well, I guess at this point, we should address the division's request.
Oh, excuse me. The public should be granted an opportunity.
Sure. Yep,
So is there anybody either in person or online that would like to comment about the per acre bond costs?
Well, hearing none, seeing none. I guess on this particular matter, there is no public comment. Haley, I see you here. Do you have anything you need to add or would like to add to this conversation?
Nope, I do not. Thank you.
Okay, thank you. Well, in this matter, I guess we need to entertain a motion to approve the division's small mine bonding request. Anybody like to make that motion?
I move that we approve the bonding costs as requested.
Is there a second?
Second.
Discussion on the motion? No discussion? We'll have a vote. All those in favor say aye.
Aye.
All those opposed? Hearing none opposed, it passes unanimously. The board has approved the division's request. So thank you for your presentation.
Thank you very much for entertaining us, and we'll see you again next year.
Some of us.
Okay.
Thank you. At this time, we'll move on to the next docketed item, docket number 2019-014, cause number C/007/005, request by the Utah Division of Oil, Gas and Mining to forfeit the reclamation surety in order to complete reclamation of the Wellington Dry Coal Cleaning Facility. It is my understanding that this has been continued until the regularly scheduled board hearing in June of 2022. Is that correct? Okay. That matter has been continued. The next docketed item is docket number 2022-002, cause number S/035/0053, in the matter of the request for agency action of Tree Farm LLC for a declaratory ruling regarding, one, the completeness of the Tree Farm's NOI small SMO S/035/0053, and two, the sufficiency of Tree Farm's proposed reclamation surety. This matter was continued from February. At this time, we'll take appearances of counsel. We'll start with the Tree Farm.
Cass Wallen from Par Brown, Gee and Loveless on behalf of Tree Farm. And with me, I have Justin Matkin of Par Brown as well.
Division.
Haley Souza with the Attorney General's Office on behalf of the Division of Oil, Gas and Mining.
Interveners.
Mike
Excuse me.
Keller.
I'm sorry.
Go ahead. Sorry. Charles Lyons here, also with the Attorney General's Office on behalf of the division.
Thank you. I'm sorry, Lloyd.
No problem.
Thank you, Chairman. Mike Keller for Intervenor Mill Creek City.
Good morning. My name's Russell Vetter. I'm with the Salt Lake City Attorney's Office, appearing on behalf of Salt Lake City.
Thank you.
And Janelle Bauer is here virtually for Intervenors Save Our Canyons.
Evan Strasberg also here virtually on behalf of Richard's Family Partnership Intervenor.
Thank you. Salt Lake City, I'm sorry, you're here. Sorry, I hadn't got your name down. I apologize. It was going faster than I could write. Well, thank you. Before we get started, I want to just discuss a few items. I know that the matter that I read into the docket, that Tree Farm has, I assume you've requested to withdraw your original request for agency action.
That's correct, Mr. Chairman. Yeah, the division and Tree Farm have entered into a stipulated motion to dismiss this matter. We've agreed to just move forward as outlined in that stipulation. And if the board would like, I could walk you through what that agreement entails.
Before you do, I just wanted to ask that in your presentations, all the parties involved, that you include a discussion as to why the board's request to evaluate a particular regulation was only that matter was only addressed by Mill Creek and Richard's Family Partnership and Save Our Canyons Tree Farm, and the division chose not to address that. And we'd like to have that as part, an explanation as to why, as part of your presentation. So I think with that, I think we'll outline how this will go forward so that we do this in an orderly manner. We'll first hear statements and presentation from Tree Farm, followed by statements and presentation from the division, and then statements and presentation from the interveners, Mill Creek, Salt Lake City, Richard's Family Partnership, and Save Our Canyons, after which there'll be an opportunity for rebuttal by the division, or sorry, Tree Farm, and then the division, and any final statements from the interveners, and followed by public comment. And prior to public comment, I think that after we've heard these presentations, we may want to specify what type of public comments are appropriate. Not that we're going to limit what people want to say, but we want to make sure that the comments are germane to the issues. So with that, I'll turn the time over to Tree Farm.
Great. Thank you, Mr. Chairman, and thank you, members of the board. As I mentioned, the division and Tree Farm have entered into a stipulated motion to dismiss. We filed that on the record on the 16th of March. Some of you may have read through what that stipulation entails, but I'm going to go ahead and explain that. First, we've agreed on behalf of Tree Farm to not continue to challenge the division's denial of the existing small mine notice of intention. We also agreed to withdraw the large mine notice of intention that is currently pending and is under review. And then we plan to refile immediately a small mine NOI on its own, not simultaneously. As you saw in the briefing, one of the division's points of challenge was that these simultaneous filings were causing difficulty within the division. And so Tree Farm has agreed that when it refiles its small mine NOI, it won't do that together with a large mine notice of intention. And Tree Farm understands that the division plans to timely review that small mine NOI. And finally, Tree Farm reserves its right under the current law to refile its large mine notice of intention prior to enlarging its small mining operations beyond 20 acres. So consistent with what the law provides. And we'll do that with sufficient lead time for the division to review it and give comments and adequately address any large mining operations that may occur in the future. And the division has agreed to that. We obviously agree to that. And so we think the proper way to move forward is to dismiss this cause and just follow the terms of that stipulation. We understand the division, after that stipulation that was entered, filed a motion for rulemaking, but our view on that motion is simply, we'd be happy to address it in substance, but we think that that rulemaking motion would be more appropriate in its own action and not on the back of this cause, mainly because not all of the industry is following this cause. It would affect a large portion of the state, a large number of operators, a large number of property owners who aren't part of this cause. And so as the division has normally done in rulemaking, we think that it should simply commence that in a separate cause. And if it feels like it needs to come before the board during a briefing session and describe the basis for that prior to filing a notice of agency action, we feel like they could do that. Again, we're not going to get into the substance of that motion unless the board specifically would like us to, but that is our position on the motion, and we feel like a dismissal here is appropriate. Thank you. Thank you. Regarding the board's question about not filing a supplemental brief, you'll recall that that original deadline, I believe, was the 9th or 10th. We had entered into discussions with the division prior to that date, and we felt like if we were going to reach an agreement, we could save the division some time, save ourselves some time in not briefing that additional issue. And so we asked for an extension of time because we were right on that deadline. Between the filing of that motion for an extension and the new deadline, we reached our agreement, filed our stipulated motion. And so in our view, these issues became moot based on that stipulation. And so we decided that it would be most efficient for the division and us not to file.
Thank you for that explanation. Division, I assume that Mr. Wallen, you've finished with your opening.
Yes.
Okay. Turn the time over to the division.
Thank you, Chairman Hansen. Similar to what petitioner has stated, because they have agreed to no longer challenge the division's denial of the small mining application and has agreed to withdraw their large mining notice of intention, the division considers this issue as moot. I understand that other parties to this proceeding do as well. And so it's for that reason that the division determined that it would not submit supplemental briefing. However, because of the growth in the state of Utah and because of the trends indicating that that growth will continue, the division believes that this cause has raised a number of policy considerations that are ripe for discussion here. The division has brainstormed a number of possible paths forward that may help address these policy concerns. But to be clear, the division is not attached to any of the specific recommendations. Rather, the division is happy to consider anything and everything that the board believes might be appropriate. It's most important to the division that it receive policy guidance on actions to take rather than specific policy guidance. Very briefly, just responding to petitioners' statements about the rulemaking process, I would remind this board most of you were around for this. I was not around for this, but most of you were. Back in 2019, Axia brought a case to request that it be granted essentially right of first refusal to develop a section or a unit essentially. And what resulted out of that was an order from the board directing the division to begin to commence stakeholder engagement for horizontal rulemaking. And so whether Axia liked it or not, that cause was a catalyst for future rulemaking efforts. And whether petitioners like it or not, the division believes that this cause is a catalyst for future rulemaking efforts. And so just because the wider mining community is not following this specific cause doesn't negate the need for doing rulemaking in general. So it may be possible for an order or a ruling to come out of this specific cause that would just kick off rulemaking, that would then be noticed appropriately with the Utah Rulemaking Act and would notice the wider mining community so that they would become involved. So the division does believe that it is appropriately docketed under this specific matter. And I have asked Director Baza to prepare some comments regarding the need for this policy guidance. And so with the board's permission, I'd request that Director Baza be allowed to share those thoughts, followed with some final commentary from myself regarding the specific suggestions contained within the motion.
Board members, any concern with Director Baza providing comments, his thoughts? Didn't think so. Go ahead, Director Baza.
Thank you, Chairman Hanson and members of the board. My name is John Baza. I'm the director for the Division of Oil, Gas, and Mining. Thank you for giving me an opportunity to express my thoughts regarding the division's motion for policy guidance. And I'm limiting my comments to the concept of that motion. The matter before you has not been a simple one. If it were simple, the division could most likely make an administrative decision that would be satisfactory for any mining applicant, would comply with existing rules, and would not be harmful or controversial to the general public. But as it has been stated most succinctly in the language of the motion, future matters of this type may increase in frequency and complexity unless actions taken by the division to provide the division, actions taken by the board to provide the division with appropriate decision-making tools to address such matters. Two factors cause the situation that we are in. First, continued urban and residential growth creates demand for the construction materials, the energy resources, and the mineral products obtained through private sector extraction activities that are regulated by statute. The second factor is the proximity of this urban growth to where these extraction activities can economically occur. This physical proximity creates conflicts where there is urban, residential, and even industrial interface with any number of other values, such as viewshed, watershed, airshed, open space, recreational areas, cultural historic resources, or wildlife habitat, to name a few. All too often, the division is faced with balancing these other values against the continued demand growth for energy and mineral resources. The only tools that we have at our disposal to achieve such balance are the statute and rules that are in place, and our ability to interpret those statutes and rules for the common good. A good friend of mine once said to me that if we can foresee a problem facing us 10 years from now, then we need to begin problem solving right now, rather than wait 10 years to begin that process. Indeed, the conflicts created in the interface of urban growth and industrial development have been with us for a long time, but we are not too late to begin finding acceptable solutions to what we know will be future conflicts. It is likely that urban growth will continue for years to come. In the past, extraction activities may have occurred far distant to population centers. That separation of distance will become less likely in the future. Some new thoughts and considerations should be given to evolving the regulatory landscape and framework to account for the conflicts that are bound to arise in years to come. The extraction industry deserves consistency of regulatory policy, and the public needs the products and materials that come from mining activities. But the conditions of the past may not apply in all future extractive development. Given fair warning, both industry and the general public can adapt to new policy, and we can develop such policy with full collaboration and transparency such that all parties may be heard and fair decisions can be made. But it needs to begin soon. Otherwise, the division will be left to make future decisions with only the tools of the past. Again, I thank you for the opportunity to provide my comments. I'm happy to discuss this and answer any questions that you may have about my comments.
Board members, do you have questions you'd like to ask Director Baza? Hearing none at this time, I guess I do have a question. I want to make sure I understand what the division is asking right now. Can you simplify exactly what you're asking today?
Yes, I certainly can. I have a little bit additional commentary to explain that, and so
Okay.
I'll launch into that now.
Proceed, please.
So Director Baza, I think, has really captured the why of what it is that the division's asking for today. I'd like to just briefly run through some of the ideas that were posed in the division's motion. So Utah code already classifies counties based on population. So the heavily populated counties along the Wasatch Front are classified as Class 1 and Class 2 counties. And the population for Class 1 and Class 2 counties range from 175,000 to over 1 million people. Currently, the rules for mining work well for mining in rural areas, which is the areas that the majority of the mining within the state occurs. But as we continue to grow, there will be an increased need for mined materials in densely populated areas. And so there will be an increased need for mining activities in densely populated areas. The division suggests heightening mining regulations in highly populated counties while maintaining the status quo in the rural counties. These heightened regulations could include requiring public participation for small mines in Class 1 and Class 2 counties, requiring division approval of small mines in Class 1 and Class 2 counties, requiring full reclamation plans for small mines in Class 1 and Class 2 counties, and reducing the acreage threshold for small mines in Class 1 and Class 2 counties. So currently, as we saw with the prior presentation from the minerals group, a small mine can be up to 20 acres in unincorporated counties. It's 10 acres in incorporated areas and 20 acres in unincorporated areas. So if the threshold for small mines in Class 1 and Class 2 counties were reduced to 5 acres, for example, in incorporated areas and 10 acres in unincorporated areas, it could help address some of the issues raised in this cause. Additionally, the coal program has a mechanism for designating sensitive areas as areas unsuitable for mining. The division suggests perhaps this could be an idea worth pursuing as well. These ideas would all require legislative changes, but the division would seek to sponsor any legislation that the board might deem necessary. And in addition to possible legislative changes, the division believes it could begin to tackle these issues within the board's currently defined scope of authority. So specifically, the division suggests undertaking rulemaking to clarify that small mine notices of intention cannot be filed simultaneously with large mine notices of intention. By setting parameters as to when a small mine can be converted into a large mine, perhaps tied to the amount of time required to mine out a small mine, for example, it could help give operators some regulatory certainty. Another thought is that the board could reassess its current rules on impact assessments that are currently required under the large mine rules. Currently, there is a requirement under the large mine, a requirement for large mine applicants to conduct an impact assessment, but there's no parameters for how the division should review that assessment. Additionally, the public health and safety measures identified in the rules limit the division to monitoring things like trash on site and plugging drill holes. That's the extent of the public's health and safety. And the division supports rulemaking to better clarify and identify what public health and safety considerations could or should be covered under the rules. So I'd like to sum up by once again reiterating the division is not attached to any of these suggestions. If the board were to reject all of these suggestions in favor of their own ideas, the division is perfectly happy. But because the board is the division's policy-making body by statute, the division can't undertake any of these actions on its own. And so what the division is specifically asking for is consideration from this board about whether there should be policy changes. And if there should, what those policy changes should be, and clear direction to the division on what actions it could or should take to address those policy actions that the board deems appropriate. So the division respectfully requests this board consider its motion for policy guidance and respectfully requests the board provide the division with direction to pursue either legislative changes, rulemaking, or both. Thank you, Chairman Hansen.
Thank you. I guess one question I have is, it seems like we have a motion within a motion. There is a motion for dismissal, and the division is submitting a motion for this policy consideration, correct?
I guess I would prefer that the motion for policy guidance be considered before the motion for dismissal.
Why didn't the division, I guess, why was it necessary for a motion from the division for policy? Why not just present it as part of your presentation of the discussion about dismissal? Why a separate motion?
Because a motion requires action. And so the division,
Did you think that the board wouldn't act on a discussion or request that wasn't a formal motion? I think we're creating some confusion in the process here. And maybe frankly, I'm not an expert in this, but it just feels like we have two motions that one was a motion that was advertised to be heard. And then we have a motion that the public or other entities really didn't have an opportunity to consider.
the motions were filed nearly contemporaneous with one another, so I'm not entirely sure.
Well, maybe it's because we we knew of the motion that was going to come before us to dismiss. And then that was followed by your motion for consideration. I think it would have been better to have a separate action, that we address the motion to dismiss and then have a discussion or a separate motion on this policy. I would have preferred it that way. I think it would have made a cleaner record. And again, I am in no way an expert in these matters, so perhaps I'm off base, but I find it a little bit disappointing, I think. First of all, this is a very difficult and contentious matter, and the public will want to comment, but what are the public going to be commenting on? Are they going to be commenting on a request for dismissal, or are they going to be commenting on a policy? And I'm not quite sure how to adequately proceed. And maybe,
Mr. Chairman,
yeah,
I would suggest that we discuss right now and get the division's input on the request to dismiss, and have all the discussion about that first, and not be discussing, the policy, because that's a big topic and needs to be thought of separately. That's what I would suggest, that all comments pertaining to the motion at hand, we handle that first. And then if we have time today, we can talk about policy, or maybe we think about it for another month. So that would be my suggestion.
Mr. Church.
Yes, Ms. Souza, I appreciate your reference to the AXIA action. And it was interesting to me that there was not a motion for guidance that brought into the rulemaking with horizontal drilling. And I think that applies here too. The very tree form case that we're looking at could result in us addressing matters without it being a formal motion. And for this cause, I definitely think we should put some space between the two motions.
I appreciate that, and I'm open to any direction that this board would like to give. If if you chose to deny the motion and directed us to file it as a notice of agency action, that's perfectly within the scope of your ability to. One comment that I would make with the AXIA matter is that you are correct. There wasn't a specific motion for policy guidance, but there was a request from the division to deny the request for agency action in lieu of doing and to do rulemaking instead. And so it wasn't done in the same way, but it is substantially similar, in my humble opinion. Thank you.
Well, thank you. I think that what Mr. Moon, Mr. Church have suggested are probably very appropriate. And I think what we'll do is go forward with the discussion on the request for dismissal, but at this time, and then we'll let the remaining parties give their presentation if you're done with yours.
Yes, I am. Thank you.
And honestly, I think some of the ideas that you've presented, the division has presented, are good ideas, but we have to make sure that we follow the proper processes to implement any regulation or policy. So we're going to have to give this some time, but let's move on with the matter that's before us on the dismissal. I will turn the time over to Mr. Keller, Mill Creek.
Thank you, Chairman. We really have no further comment. We appreciate the opportunity that the board gave us to intervene. And we indicated when we filed our supplemental brief, which I had already drafted, and I didn't receive direction from the board not to do so. So I went.
Thank you that you did.
Not to get in someone else's face, but it seemed to me that the board was interested in the issue, even notwithstanding the fact that then we suddenly were confronted with the dismissal, which addresses the immediate matters of the division and tree farm. But anyway, we support the division's motion insofar as and Mr. Director Boz's comments. I think those are well taken and worthy of consideration by the board under whatever process the board deems appropriate.
Thank you. And again, thank you for addressing the issue that the board requested in the last hearing. Well, we'll turn it over to Salt Lake City.
Again, my name is Russell Vetter. I'm with the Salt Lake City Attorney's Office here.
Can you spell your last name, please?
V as in Victor, E-T-T-E-R.
Thank you.
The Salt Lake City joins and supports the comments that Mr. Keller made from representing the city of Mill Creek, as well as the division's comments and concerns. I'm guessing you may hear from some of the public comments. There's a petition that's being circulated that apparently has over 20,000 signatures expressing concern about the tree farm applications. And we have good reason to believe a significant number of those folks are residents and citizens of Salt Lake City. So this is a significant concern for the city. The procedure that the division has proposed, and I certainly appreciate the quandary that's maybe been created, in part has been because of tree farms filing the two NOIs at the same time. And it does seem appropriate to look at some of those issues that the division has raised in the context of the tree farm applications. So if timing is a concern, this matter has been continued twice. It doesn't seem that it would necessarily prejudice tree farm to keep them together. And as an alternative, we might suggest consideration being given to hearing the comments today, but continue the final decision on the dismissal for another month while folks at the same time have an opportunity to address the division's motion if the board concludes that procedurally there wasn't a fair opportunity for people to weigh in on that. So that's all we have. Thanks for your time and allowing us to speak.
Thank you. You know, one thing I didn't do is with Mr. Keller, were there any questions from the board for Mr. Keller? Any for Mr. Vetter? Thank you for your comments. We'll turn it over to the Richards Family Partnership.
Good morning, Evan Strasberg on behalf of the Richards Family Partnership. I just want to add a couple of comments and certainly endorse what has been said thus far by the division and the other intervening parties. And I just want to make a couple of points. The Richards Family Partnership owns property that is adjacent to what is proposed to become the mining operation. And so all of the issues, all of the concerns that have been raised by various interveners, by the public, are felt most acutely and will be felt most acutely by my clients. And so they have a very serious concern and very significant interest in these proceedings. With respect to, and I understand that we're addressing a discrete issue here with respect to the motion to dismiss. And I don't pretend to say that we can necessarily keep parties in a proceeding that they don't want to be in. But our primary concern is that the tree farm has clearly indicated its intent with respect to this mining operation. It's not going to be a small mine. It will be a large one. And my concern is that we don't allow this dismissal, this procedural mechanism to become a means of avoiding the serious issues and concerns that have been raised with respect to commencing mining operations, knowing this is going to be a large mine. And the intent is for it to be a large mine for a substantial period of time. And so our concern is that we believe, and as we expressed in our supplemental briefing, that there is authority for the board and the division to concern itself with public health and safety, and that those concerns be addressed before mining operations are allowed to begin. And that's really all I wanted to say on behalf of the client at this point in time. If there are any questions, I'm happy to address them.
Board members, do you have questions? Mr. Moon?
Yeah, so how would a small mine approval in any way diminish tree farm's requirements in requesting a large mine? I mean, the fact that a large mine could happen after a small mine, how is that making it easier for them to get a large mine, would be my question.
I don't know that I have any specific comments on whether it makes them easier to get the large mine, but the concern is that by the time we get there, all of these concerns that have been raised with respect to the impact on environment, with respect to a fundamental change in the nature of what's happening in the area, all of those things have already happened. And the concern is that by simply withdrawing a large mining application, you're saying, okay, we don't have to concern ourselves with any of those things before we begin operations. And all of those concerns and all of those problems and all of those effects that have been discussed begin to be experienced by my clients as well as others. So it's not necessarily an issue of what happens with the large mine. We're now sort of past the point of no return with respect to the impacts that have been identified.
Okay, thank you.
Just to follow up on that, I assume the whole reason small mines were singled out for different treatment than large mines is because the impacts by definition are much smaller as far as direct disturbance, dust, tonnage moved. So they are a different scale of impact, if you will, than a large mine. And a large mine, I believe that's the rationale for having a much more rigorous process, because by definition, a large mine would have much larger impacts in all those areas. Any comments on that?
I don't pretend to be an expert on that in terms of the reasons for it. I don't doubt that that's correct, but to say that the impacts might be less doesn't mean that the impacts will be non-existent. And all that we are asking is that the board and the division exercise whatever power, whatever authority they have, and we believe that authority is fairly broad as specified in the statute with respect to ensuring that operations are conducted to minimize or prevent hazards to public health and safety, that those not be pushed off at some point in the future when a large mining application is finally presented and considered, that those be addressed as soon as possible, because the effects, whether they are less than what they will be with a large mine or not, will be felt, and will be felt most acutely by my clients.
Any other questions for Mr. Strasberg? Hearing none, we will go to Ms. Bauer with Save Our Canyons.
Thank you for having me today. I'm sorry I can't be there in person. I'm a little under the weather, so hopefully you can hear me and my shaky voice today. I just have a couple of comments. First of all, to address the conversation that was just happening, I think this is one of the reasons why it's so important for the division to consider the policy making motion that was filed, because you may not have immediate impacts in a class 3 or class 4 county from a small mining operation. But in a class 1 or class 2 county, there are going to be immediate impacts to health and air quality, water, all of the things that my clients have brought up in their comments, as well as the public and the Mr. Strasberg's clients. Those impacts are going to be felt immediately with neighbors right next door to the small mining operation. And I think this is one of the reasons why the policy guidance motion from the division is so important, because you can't find areas where there will not be impacts in a class 1 or class 2 county for a mining operation, regardless of its size. And I think that that needs to be addressed by the division. Also, there is a procedure for you to order as a board an emergency order on a moratorium to prevent any processing of small mining operations while this policy motion is being evaluated by the division. That moratorium is allowed under your statutes as well as the Utah Administrative Procedure Act. And I think that would be appropriate here. A lot of times when you have a legislative body, for instance, a city or a county reviewing their general plan, there's a moratorium on processing building applications. And that would be the same here, so that the impacts of the tree farm small mining operation, as well as others that may be coming, are evaluated by the division, and hopefully public input is allowed into that process. As you can see here, there's a lot of people that are involved in this tree farm process and want to be involved in that public process. And taking that right away from them when they will have immediate impacts is not something that a government agency should really be doing. And that's all I've got.
Thank you. Board members, do you have questions for Ms. Bauer? Mr. Church.
Ms. Bauer, do you have some references for us under the statute that you're referring to where we have this obligation or to put things on hold?
Sure.
Or power to do so?
I do. Under Utah Code 63G-4-5, it's the Utah Administrative Procedures Act. Part 502(1), an agency may issue an order on an emergency basis without complying with the requirements of this chapter if the facts known by the agency or presented to the agency show that an immediate and significant danger to the public health, safety, or welfare exists, and the threat requires immediate action by the agency. I think that threat to the public health, safety, and welfare has been well documented by my clients, as well as the Richardson Family Partnership and others from the public that have commented about the impacts that they will experience if this SMO is approved.
Thank you for that reference.
You're welcome. Also, under 40-6-10 Part 2, which is part of your code, when an emergency requiring immediate action is found by the division director or any board member to exist, the division director or board member may issue an emergency order according to the requirements of the of Title 63G, Chapter 4, Administrative Procedures Act. So there's your reference into the section I just read.
Board members, any other comments or questions for her? Thank you for your comments. I want to ask a few questions of the division on procedure. For a small mine NOI, while there is no, under the current rules, no opportunity for public comment, if you were to approve a small mine NOI, would the public not have the opportunity to come before the board and request that that approval be rescinded or rejected?
I suppose that's within the realm of reason, but let's look at the board's rules. A petitioner is anyone who initiates a proceeding. To be completely honest, Chairman Hansen, I don't have a specific answer for you. I think that it's definitely possible, but I would like to have some more time with the rules and time to think about it. That's not something that I had previously thought of before.
Okay. Another question. Before a small mine NOI is approved, does not the applicant need to demonstrate that they have all other permits in line? They do not?
No, they do not. So it is the division's preference that the applicant have the other permits, and then those permits will be included as an appendix to the permit. However, many other agencies require that applicants have an approval, a permit from DOGM before they will then process their permit. So what oftentimes happen, what I would say the majority of the time happens, is that we issue our small mine permit with a cover letter that says, don't forget, you have to comply with all of the other state statutes and regulations. And by the way, when you get those permits, please send them to us so that we can include them in the permit as an appendix.
But obtaining a small mine NOI approval does not preclude them or allow them to start mining if they don't have these other permits, right? I mean,
That is correct.
They would be breaking the law if they were to operate without an air quality permit or any number of permits that they have to obtain before they can start turning dirt.
That is correct.
Okay, and I assume, appeal processes related to those other permits as well.
I would imagine.
Okay. Perhaps I should be asking this of Salt Lake City or Mill Creek. I assume that if somebody came before you to obtain a permit, that you would expect them to obtain that before they started any kind of work. Would that be correct?
We require building permits within the city if somebody's going to be constructing something. Now, this, of course, is not in Salt Lake City boundaries. It's in the county, unincorporated area.
Right.
So
right.
I can't speak for the county.
Sure, fair enough. I'm just trying to make sure that, we don't get so focused on the Division of Oil, Gas and Mining requiring a permit to do work that no other permitting agencies are involved. I mean, my experience is that in mining that there are quite a number of permits you have to obtain before you can actually create a disturbance. So I appreciate that information, Division. Thank you. Mr. Church.
Just as a follow-up to that, Mr. Chairman, how do incorporated entities, how do their zoning laws and regulations affect an NOI for a small mine? Do they preclude it if it's already mentioned in the zoning that it's precluded, that there's no permit that can be granted?
So our rules don't specifically direct the division to consider right of entry like the coal rules do. That could potentially be something else that we would look at, but essentially we don't consider right of entry. So even if the zoning say no, mining is not allowed here, we would still issue a permit and say you need to comply with everything else. So if they go to the county and county says no way, Jose, then they're still precluded from mining with the zoning, but it's not something that the division considers.
I'd also like to have a couple questions for the division. I'd just like to explore a little more the rationale for even making a differentiation between a small and a large mine as far as the division is concerned. What is the justification for having less rigorous requirements for a small mine?
That's what we've been directed to do by the legislature.
Okay, that's good to know. And the second question is, we're talking about a lot of issues of the interactions between a small mine and a populated area, but wouldn't it be just as easy to have those same interactions in a county that's not highly populated but has one city in it if there's a proposed small mine right next to the town?
I do think that that is possible. I think that and probably Dana, if she's online, may be able to speak more, or Wayne may be able to speak more about mines that we do have that are in that situation. And it's my understanding, and actually this isn't based in fact, this is just what I think is probably true. So just clear disclaimer there, that we just don't get the amount of public comment and the desire to engage publicly in those situations as we do in the populated counties along the Wasatch Front.
And one last question for you. This is, again, revisiting something that was said before, but I just want to hear it from you quite clearly. The existence of a small mine, does it in any way change the fact that the division can approve or deny a later large mining NOI application
That
in
is
that
correct.
same area?
Mhm.
Does not change that.
No.
Thank you.
Yes, I'm sorry. Go ahead, Mr. Keller.
I'm going to get a little off probably my role here, but having practiced natural resource law for years, I would say that likely one motivation with the legislature on the distinction, although I think probably we don't know exactly, and I have not researched the history as it might be available. But I do think that development in the federal public lands under the mining law of 1872 may have been in the thoughts of our legislature to facilitate the development of federal minerals, allowing applicants to go forward with state permitting and not be delayed. Also, there are matters of law that affect the ability of local governments to regulate activities on federal lands and on unpatented mining claims outside of, in a county, and the ability of a county or municipality to regulate activities on private lands is one thing, and to regulate federal might be different. So I don't want to go way into the weeds, but probably the legislature's thinking was most likely that smaller has less impact, but I do think there are also motivations to facilitate the development of mining under the general mining law on federal public lands that the Utah legislature, at least in my experience, would be interested in encouraging. But that's just since I'm here, I offered those thoughts, and there's no chapter and verse that I'm referencing or citing that might make a distinction between those kinds of situations and these difficult situations of active mining within highly populated areas, which is inevitably going to raise concerns of lots of folks. And as well as the division rightly points out, there is a need for the materials. So the public wants materials for their driveway, and they don't want to be impacted. And so these are difficult issues for all policymakers. I'll close with that.
Thank you. Mr. Moon.
Yeah, just quickly, a question for Tree Farm. Where are you with Salt Lake County? You need a conditional use permit, I would assume. What are those steps, and where are you at there? Or like, do you view this as the first step and something they would require? And just where you at on that?
Yeah, thank you, Mr. Moon. Yes, we view this as the first step. A lot of operators take the same approach in coming to Dogum first. We think that if we went to the county without coming to Dogum first, they would say, why didn't you go to Dogum? And so this provides kind of a more robust mining review. This is the mining regulatory authority from the state. So we started here.
Could I also follow up with a question with Tree Farm? I just want to explore a little bit the rationale for submitting an NOI for a small mine. You have a large resource there. You have a very large market, which probably would mean you'd want to develop a large chunk of that resource rather than, I think the small mine I worked up is a couple of % of the resource you might be able to access. So there's a lot of uncertainty to buy equipment, to start up the process if you don't know you're going to get a full-scale mine, which is probably where the payoff comes in the long run is for your upfront investment. Why not just permit the large mine right away?
Well, yeah, thank you, Mr. Borden. I mean, it was our thinking in the initial filing is file a small mine, file a large mine, because the statute allows for that to happen and allows for the division to review both of those at the same time, understanding that the large mine would take a bit longer because it's a more robust and comprehensive review, but at the same time, have a review on a small mine, which is also allowed. And right now, just to be frank, after our discussions with the division, this is more of a procedural problem than an operational problem. And the division said, well, to fix our procedural problem, why don't you just withdraw your large mine? And we thought, okay, we'll go ahead and we'll withdraw the large mine. We'll only have a small mine on the table, and that will fix our procedural problem.
I guess I was trying to get at, let's say you start the small mine, you buy that equipment, you invest that capital, you're putting that capital at risk until you know you have a large mine that's permittable. So I'm just curious, your thoughts on putting that capital at risk when you don't know if you're going to have a large economic long life operation.
Agree, that is a risk. That is a risk, and that's a risk that this operator is going to be taking. Future operations, we don't know if they'll be approved, what they'll look like, et cetera. And so that is a risk. I absolutely agree.
If I may, Justin Matkin, as Mr. Wallen said, that I mean, there is a strategic, not a strategic decision, but essentially economic decision that the small mine is a viable operation in and of itself. That there's quite a bit of material there that could be taken out from the 20 acres. The large mine, well, I think, just to be frank, the public sentiment here has kind of caught us off guard a little bit. This has become kind of a more involved process than we were anticipating. We didn't view the simultaneous filing of a large mine and a small mine application together to be so controversial, or to get the pushback that it did. And so this is essentially, as Cass said, attempting to allow us to move forward with the small mine, taking the economic risk associated with it. But clearly, from our point of view, the small mine is a self-sustainable, viable operation in and of itself. And we understand that the large mine probably is going to be, a multi-year process to get that approved and to deal with, like you said, potentially appeals going forward and issues with the county and any other issues that may come forward, given the public sentiment here. So this is essentially us trying to operate under the rules to proceed with the economic plan that we believe is viable and permitted, while allowing the large mine application to proceed kind of on its own course.
Sorry,
Thank you.
having to share our microphones. Any other questions from Mr. Moon?
It's kind of a big picture question that's, and your clients aren't here to answer, but, and that was one of my questions, is this would a 20-acre mine be economic, and would you actually do it, or would you just,
So we actually do have our clients here, and
okay.
if you'd like, we could bring them up to.
Because my question is, because we've seen references, this whole 600 acres is going to become a mine. I pulled up just for reference across the road, the Harper mine is about 100 acres. It is steeper, so there's a lot more material in a smaller acreage. But just big picture, what you do the small mine, it is economic. You do ask for a large mine. Are we talking a 400 or 500 acre mine, or are we talking a 100-acre mine? Just so the public has a chance to hear from you what the big plan is, so that we, keep it in context.
So if I may, I appreciate that. I understand that everyone's interested in what's going to happen in the future, and what our plans are. At this point, we have agreed with the division to withdraw our large mine application. So there will be no large mine application pending. So what that looks like in the future, I think, is going to be open to negotiation with the division, open to discussion with engineering and with what made sense economically. Hopefully, eventually, probably in participation with, public entities that are available to us to the permitted entities in addition to the Division of Oil, Gas, and Mining. So I would like to be able to say, this is what it's going to look like. This is what it's going to be. I don't think we know that yet. What we do know is that we will have a maximum disturbance area of 20 acres. And our client has determined that 20-acre disturbance and the material within that 20 acres is a viable standalone operation. It is taking a risk. There's expenses to developing a small mine. The large mine eventually will be filed, and what that looks like, I can't presume to predict that at this point.
Thank you. Good.
Thank you. I guess I just have one more question to the division. In your memorandum, or in your memo, or request, I should say, for motion on the policy, one of the suggestions was to reduce the size of an operation in a class 1 or class 2 county. Just as a hypothetical, what if I have 20 acres on the south end of Lake Mountain in Utah County? There's nobody around for many miles. Would I still be restricted to a smaller operation under this policy?
Well, I think it depends on what this board would want to see and what we were ultimately able to get through the legislature.
I guess, and I should have qualified that. We've been asked by some parties, including Ms. Buell, that the board issue a moratorium. And would that moratorium impact an instance like that, where a person wanted to mine an area in a class 1 or class 2, but is located some distance from a population center?
I think for the interest of administering any potential order, having bright lines is useful and helpful. And so I understand there may be these kind of stickier issues where, sure, it's a class 1 county and it's, in a less densely populated area. And in the interest of administering it, I think that it would be best to have bright line blanket rule, understanding that, it may affect some people differently.
Okay, I appreciate that advice. If there are no more questions, we'll go. Okay, Mr. Rich, go ahead.
I'm sorry. There's a lot to unpack in this, as you all know. This is one last question, I promise, for the division. The rule is currently written. I'm going to present a hypothetical to you. Small mine, 15 acres, low population county, far out in the desert. But it's an ore body that, as often happens with metals ore bodies in particular, it has a species that is evolved on that, which only exists over that ore body. And the mining would remove most of that species, which only exists in that one spot. Doesn't impact anybody, but it's very harmful, unavoidable harm to an endemic species. Would you have to approve the small mine as the rules are currently written?
No, in fact, we wouldn't even consider that species.
You would not consider the species?
No.
And so you would just have to approve the small mine?
Correct.
Thank you.
Well, at this point, if there are no other questions or comments, why don't we go ahead and turn back over to Tree Farm for rebuttal?
Thank you, Mr. Hanson. So as Mr. Matkin mentioned, we did not view this as being a very controversial matter. It just turned into quite the matter with a lot of people and parties interested. But I think this boils down to essentially the main parties to this action, which are Tree Farm and the division, have agreed on a course forward. Other parties, including interveners or members of the public that may have made suggestions, have not really focused on that aspect, which is the division and Tree Farm have agreed on a procedural way forward. And there's nothing controversial about the procedure of it. I think where we're getting hung up is on the supplemental motion, which again, I think underscores why we would want to handle that in a full separate matter with everybody noticed that would be affected. Let me also just address the comment that this notion that a small mine would actually be a large mine. That is absolutely not the case. It would be impossible for this to be a large mine. It will be a small mine limited to a maximum of 20 acres of disturbance. It is not a large mine. The large mine is going to be withdrawn entirely. There will be a separate time in the future, perhaps, when a large mine comes in, and that application will be reviewed by the division. The future small mine that will be filed right after this is going to be reviewed by the division as well. No, the small that will be filed immediately after, yes. It will be reviewed by the division as well under the rules. Those operations will be subject to other review. We've talked about this today. So the notion that, well, they're proceeding under this, but it's really a large mine is not only not supported by the record, it's just untrue. There's also a fundamental misunderstanding in the distinction between a large mine and a small mine. This is a statutory distinction. This is not something the board can simply ignore and say, well, we think this is going to eventually become a large mine. And the fact is the statutes provide for a distinction between those types of operations. And when an applicant files a small mine NOI, that applicant is entitled to have it reviewed, and the division can provide any comments to that application and move forward from there. but construing it in a manner that is inconsistent with what's on the filed NOI would be completely baseless. Let me also address that the concept of an emergency order that has been raised, or a moratorium, the filing of a small mine NOI does not rise to the level of an emergency order or an immediate threat to the public health and safety. As we've mentioned, there will be a review procedure for that small mine. An emergency situation would be, for example, a dam failure that's imminent. The board issues an order, an emergency order that will imminently protect the immediate public harm. The action that's on the table here is Tree Farm is going to file a new small mine application. That in no way rises to the level of an immediate public health and safety concern. It'll be reviewed. So the last thing that I'll say is the purpose behind the Utah Mined Land Reclamation Act, which is the governing statute over the board and over the division, contemplates that for mining activity, that disturbance is adequately reclaimed. And the mechanism to ensure that that mining activity is adequately reclaimed is a reclamation surety. Granite will post an adequate reclamation surety consistent with what the division determines to be the appropriate reclamation amount. And again, we'll go forward with any other necessary reviews and approvals that will protect any sort of health or safety concern that are associated with a 20-acre mine, which I might add are very minimal. And that's why the state legislature has drawn the distinction between large and small operations. So with that, we'll conclude. And again, we think the cleanest way forward here is simply to grant the stipulated motion to dismiss, to simply deny the division's secondarily filed motion. And that wouldn't speak to any of the policy or other ideas. It would simply be to indicate that the division should bring that matter up in a different forum. This matter only has a limited number of folks that are participating in it. And I can tell you, I have other clients, and there are many other operators and property owners that would want to be part of that proceeding and would want to have notice. There's simply no rule and no reason to have the board say to the division, go ahead, you're authorized to consider rulemaking. They can do that at any point and bring that matter to the board. So we'll conclude with that. Thank you very much.
Good. If I could just make one comment. This is the first process. This is the first permit in a series of permits that we're going to be required to obtain. So because this is the first time that the public has had a chance to kind of participate in this, I think we're going to hear a lot of comments that are probably outside the jurisdiction or the normal area of expertise of the division or the board. And so we have to go to the Department of Air Quality. We have to get water quality permit. There are a bunch of things that we're going to need to do. And this board and this division is not Environmental Protection Agency, right? There are other entities, other departments, divisions of the state of Utah who are tasked with the authority and the expertise to review air quality, to review water issues, to review environmental issues, and so to review zoning issues, right? This board is not that. The division is not that. And so I think probably what we're going to hear, and I just want to kind of caution everyone before everyone gets too excited about some of the comments that I'm sure we're going to hear, is that we just need everyone. I think my caution is just we should stay in our own lane on these issues and not allow DOGM essentially to become the Environmental Protection Agency of the state of Utah when it comes to issues that its employees and its don't really have expertise to evaluate. And so those issues will be evaluated, permits will be reviewed and considered. All those things will be done in due course. But I think we're going to hear a lot of things. Don't know. I'm just anticipating based on the comment letters that have come through that we're going to hear a lot of things that are going to, the world's falling. We're all going to die from, whatever. But I just want to make the point, the final point, which is this is the beginning of a long process, and there's other divisions of the state who are involved in it, other entities of the state who are involved in it, subdivisions of the state like Salt Lake County. And so this is the division of mining is essentially focused on how do you construct and operate a safe mine, not how do you deal with all the other myriad things that are out there that we're about ready to hear. So thank you very much for your time. We appreciate your thoughtful consideration.
Thank you. Division, turn the time over to you for rebuttal.
Thank you. I only have a couple comments. In the interest of full disclosure, the division's preference in settlement negotiations was that the petitioner withdraw its small mine NOI and to pursue only the large mine NOI. Petitioner assured us that they wanted the small mine, that they wanted to move forward with mining that material. And so because withdrawing the large mine application, the large mine NOI would resolve this, administrative piece, then the division was willing to accept that, understanding that there were other permits that they would need to obtain prior to engaging in small mining operations. The division believes that this is the appropriate forum for thinking about, considering, providing discussion on possible policy changes moving forward. And we do not believe that by having it in this forum, as opposed to a notice of agency action, will preclude anyone from engaging in the conversations, because if we were to undertake rulemaking, we would need to have stakeholder engagements. We would need to comply with the Utah Administrative Rulemaking Act. We would need to put it for public comment. We would need to engage in stakeholder discussions prior to enacting any sort of rulemaking changes. We reiterate, we believe that this is the appropriate forum for having this conversation because this is the forum that brought up these issues. It's the division's opinion that if we were to do it under a notice of agency action that puts us out 45 days and now we're talking about May, we forget. So the thoughts are fresh right now. That's why we believe that it's appropriate to do it here instead of 45 days from now. And so we respectfully request that you consider the division's motion for policy guidance and to ruminate and to provide the division with direction moving forward. Because Tree Farm has agreed to withdraw their notice of intention for large mining operations, the division believes that the issues that were presented in this specific petition are moot, and so the division supports dismissal of the action to the extent that it's moot. And those are my thoughts. Thank you. Oh, wait, actually, I take it back. Just for clarification, we have not taken a position on the appropriateness of an emergency order or a moratorium, and we do not have a position on that.
Okay, thank you.
Thank you.
Do you have a comment, Mr. Church?
Yes, Ms. Souza, however appropriate you feel it is for us to address your motion now, if that motion for guidance would be denied, would that in any way restrict the division from going forward and interacting with the board and proceeding with rulemaking?
I would expect that if the board were to deny the division's motion, we would probably take our motion, title it a notice of agency action, and file it in short order.
Thank you. Well, any final statements from the interveners? Mill Creek?
Nothing further, Mr. Chairman.
Thank you. Salt Lake City?
No, nothing further. Thank you.
Richards Family Partnership?
Nothing further. Thank you.
Thank you. Save Our Canyons?
I just have one quick comment to address something that the petitioner said about being outside your lane when considering environmental impacts, water impacts, air quality impacts. In part 440-8-12, the objectives of the Utah Mine Land Reclamation Act specifically request that you consider the ecologic and hydrologic regimes and to meet other pertinent state and federal regulations regarding air and water quality standards and health and safety criteria, and to minimize or prevent future hazards to the public safety and welfare. I think all of these are in your lane, and comments on these issues are appropriate from the public as well as the other interveners. And that's all I've got.
Thank you. Well, I think at this time, we will accept public comment on this matter, but I want to, in the interest of keeping the comments focused on the matters at hand, one, I would like to say, if you have already made a written comment and submitted it, and you don't have any material changes to that comment, that there is no need for a repetition of what you've already submitted, if I am saying that clearly. We appreciate the written comments. I have read every single one of them, and we will all take those comments into consideration in our decision. But again, if you're going to make a public comment today, please don't repeat what you've already written to us. We've seen it and we've heard it, and we're paying attention to it. Also, I would prefer that we discuss the matters at hand in our public comments. And in the interest of time, because there are apparently quite a few that would like to make comments, we would like to limit those comments to 2 minutes. And when you have 10 or 15 seconds remaining in your comment, you'll be reminded that you have that amount of time remaining. Because we're doing this electronically, this is a little bit difficult, and maybe the first thing that we would do is, if there's anybody in the audience that would like to come up and make a comment, we will do that first, and then we will go to those who are in the participating virtually. I'm not sure how we can order you in your comments, so you'll just have to, I'm afraid you'll just have to speak up, and we'll try and recognize you and let you make a comment. Board members, do you have anything you'd like to add? Any advice? Yeah, that's a good reminder. Raise your hand function that's available to you, and then we can see that. It'll be displayed on the main screen above us, and we'll call you by name, I hope. So without any other explanation or discussion, is there anybody here personally present in the auditorium that would like to make a comment? Seeing none. Hold on just a moment, please. All right, we'll go to those who are participating virtually, and I see that there's Mr. Andrew Smith that has his hand raised. Would you please go ahead?
Yes, thank you. I just wanted to make a clarification. 20 or 30 minutes ago, there was a discussion and a comparison to the current at exit 131 on the north side of I-80, the Kilgore/Harper mine. It was mentioned that it was around 100 acres. From all that I can ever be determined and what we've been told, it's more like 11.2 acres, not 100 acres. 100 acres is quite a bit more than 11.2. I wanted to make that to be on the record that it's not 100 acres at this point. And in comparison with the proposed at exit 132, the proposed new small mine of 20 acres, roughly the same size, but that's something that maybe a lot of the people listening might have heard, and I just wanted that to be corrected. Thank you.
Thank you. Appreciate that comment. We will go on to the next person, Sherry Jackson.
Hello, I'm Sherry Jackson. I serve on the Mill Creek City Council. I represent the Canyon Room neighborhood, which is directly west of the mouth of Parley's Canyon. The petitioner has claimed that the small mine application is not at the level of immediate threat. I would contend differently. The fact that this discussion has brought up the need for a consideration of your rules and reviewing and maybe altering the rules process indicates that it is a threat, that there is significant need to address the impact that a small mine creates in a residential neighborhood. Our neighborhood is 70 years old. We're not encroaching on mining territory. This mine is actually encroaching on our neighborhood. Parley's Canyon acts as a funnel, and any dust that is stirred up by 20 acres or a smaller amount will add to the already existing fugitive dust that comes down that canyon and coats our homes, coats our cars, becomes a problem to having our windows open because our homes are filled with dust. And so I would ask that you consider the rules making and revisiting those processes, and if it's within your jurisdiction, put a moratorium on any additional mine applications while you go through this process and consider the impacts on nearby residential communities. Thank you.
Thank you. Appreciate that comment. We'll go to the next person, Jan Hemming. You have your hand up.
Yes, distinguished board. I am Janet Hemming, Chair of the Elkhurst Neighborhood between reason, sanity, common great sense.
I'm sorry, Ms. Hemming.
One
we have a
hand,
poor connection. We're not getting.
And money and personal ambition on the other. Tree Farm wants. Can you hear me?
I'm sorry. There's a problem, I think, with the connection.
Can you hear me?
Yes, I think we can hear you, but I believe you're exceeding your bandwidth. But so we're only getting about one every fifth or sixth word.
I'm wondering if I need to go to this and see if I can find a better location. Can you hear me now?
Oh, I see. We're being advised maybe you should turn off your camera. It'll take up less bandwidth.
Can you hear me now?
Yes.
Oh. All right. Is it better?
So far. Please start again. If we continue to have problems, you may have to call in on phone, but please go ahead.
All right. Let me start again. Thank you. Distinguished board. I'm Janet Hemming, Chair of the Oakhurst Neighborhood Council. Tens of thousands have signed petitions with the hope that your board will be a great barrier, the successful Maginot Line between reason, sanity, common sense on one hand, and money and personal ambition on the other. Tree Farm wants to outmaneuver you. And use every tactic possible to impose its will. A small mining operation is merely the nose of the camel in the tent, despite their statements this morning to the contrary. The idea that Tree Farm can reconstitute this beautiful, one-of-a-kind property after destroying it lacks all credibility. My request is that you declare a moratorium on processing any new SMO NOIs, and secondly, that you take the legal, legislative, and procedural steps to prohibit any and all future mining proposals in Parley's Canyon or in similar pristine watershed locations submitted by Tree Farm or any other company. For centuries, Parley's Canyon has stood as a shining example of Utah's natural beauty and breathtaking scenery. Let's keep it that way. Thank you.
Thank you, Ms. Hemming. If you would you mind submitting your comments, written comments to Julianne? Just email it to her. There was a short moment in there that we missed part of your comment.
Yes, I'd be happy to do that.
Thank you.
Thank you.
Next up, we have Shelley Rich. Miss Rich, can you hear us? We do not hear you. You're still muted.
Here we go. Okay. Can you hear
There
me
you are.
now?
Yes, we can.
Okay. Thank you. This morning has been so enlightening. I have submitted many letters, and I come to you this morning from my classroom at Hawthorne Elementary, one of the weather stations across the valley. And I represent the 400 students I teach art to here every week. It's a very active place of creativity and life, and I speak for my students here that deserve fresh air. There have been so many days in the last couple years that we've lost the chance to be outdoors at recess because of particulate matter in the air, and to continue to even consider a mine that is going to stir up even more to contribute to one of the biggest, hardest things that we have in our whole city here is bad air. Also, their plea is to keep the natural world, as is mine, untouched. And when I hear Tree Farms talking about, well, the least invasive way to the environment is to do a smaller mine, but the least invasive way is to just never do it in the first place. And I really appreciate Save Our Canyons and all the people that have come on board to help us realize the natural resource that we have, that we can't, there's no way of going about a mine of any kind in that neighborhood that's going to be amenable to all of us that live there. I live in Mount Air Canyon. I'm a 5th generation girl there. I can't even begin to talk about the heartbreak. Every time I see OMG, gee, what's the name of your organization?
15 seconds,
OMG
15 seconds.
because that was my response last November as I came out of the gate at exit 132 and realized what we were up against. I really appreciate all of you people. It's been so interesting to listen and to see what you're passionate about. What we have I think what we need to ask ourselves here is what can we control and what we can't. And I appreciate your time. I appreciate the fact that we as citizens are able to speak and to share our passion for the jobs that you do every day. I've learned a lot. It's a journey that has taken me to consider geology and the mines
has
that are all
expired.
across our beautiful state, which I've lived in and loved my entire life. So I am an impassioned citizen speaking for those of us that wish this to never be, and whatever you can do to stop it, I'm all for it. And I speak also for the students here at Hawthorne Elementary. And I say thank you so much.
Thank you. We'll move on to Mr. Williams, SD Williams.
Yes. Thank you, Williams. Can you hear me?
Yes, go ahead.
Thank you. I served for 12 years in the Utah Department of Health as a division director, then deputy director, and eventually as the executive director. And I'm also an interested cabin owner in Mount Air. A couple things and I'm the one who issued a request for an emergency order. I petitioned the board to issue an emergency order. A couple things that have come up today that I'd just like to comment on. One is the division's attorneys who mentioned that it was Tree Farm's preference to pursue their large mining operation, NLI. I think it's just a clear indication that what they're doing now in submitting an SMO is just a small mine masquerading as a large mining plan. And I think the board and the division needs to take that into consideration. I also think that the public health impacts of this, even as a small mine, because of the mine across the canyon, now we have at least a 30-acre, if not a larger impact, and it's effectively on the population downwind, a large mine. And so that's another issue that I think comes up in the division's request for clarification on policy, is if there's two small mines right next to each other, in terms of the impact on the public, it's a large mine, and the rules don't really address that. I would disagree with Tree Farm's attorneys that it's not your lane to deal with public health issues. It's clearly in your code, or in the code says you have the authority to issue a emergency order if public health is threatened. And the question is, when is it that you would know that public health was threatened? And I would encourage you to consult with the Division of Air Quality about that. And if you don't issue an emergency order, I would suggest that perhaps you continue this issue and not dismiss the case and not allow a resubmission of an SMO until the impacts in the public health nature of this mine is clear to you. And then finally, in terms of your question on the remote areas of Utah County and the impact of an order, the legislature has created the ability for counties to create a critical infrastructure materials zone. So you could exclude critical materials infrastructure zone from your order and still put a moratorium on SMO NOIs in areas that are not in those zones. So thank you very much, and I appreciate your service on this board. You have a tough job. Thanks.
Thank you. Appreciate your comments. We'll go on to Dr. Daniel Chappelle.
Yeah, can you hear me?
Yes.
So I'm also a cabin owner up in Mount Air Canyon. I'm in agreement with everyone that's spoken to that end, save our canyons and the cities and those in pushing for a moratorium until we can get more information as your board on the health impacts of this mine and mining operation, whether it's large or small. There will be an impact, as has been said before. And so I'm just for and agree with the others that have spoken to that end. Thank you for your time.
Thank you for your comments. We have others that are on the phone. I'm not sure if they're wanting to make a comment. You might have to help us out here, Paul. I don't see any other raised hands.
For those participating remotely via the telephone, if you'd like to press *6 and announce yourself, please come one at a time. But for anyone connected in via telephone, if you could identify yourself if you wish to comment at this time. Again, *6 to unmute.
Thanks, Paul. Well, not hearing any. Just if there's anybody on the phone that does want to make a comment that is having difficulty communicating with us, just go ahead and speak up. If again, there's always an opportunity to submit your comments electronically as well. Well, I believe that we'll close the public comment portion of this discussion.
Mr. Chairman, if I could inject one more technology component.
Sure.
We just activated the online chat. If you, before the chairman makes a last call for comment, if you are having a technical issue and you're unable to address the board, if you would send a chat message real quick, we will close that chat at the conclusion of the next commenter. again, please reach out and chat and identify yourself.
Okay, we have one other hand that was raised. Sam Dunham.
Hi, this is
If you
Liz
wanna go
Dunham.
ahead.
Can you hear me?
Okay, yep,
This
we
is-
can hear you.
Sorry, I was trying to do it by cell phone. It did not work. So I'm going to go here. My name is Liz Dunham. I'm speaking for the moms in Mount Air, Canyon Rim, and Mill Creek. There have been parties on this meeting that have a personal interest in approval of this mine, and I'm speaking to them as well. My children attended school at Eastwood Elementary at the mouth of Parley's Canyon. There were many days that could not go outside because of the air quality, and Jesse Lassley, which is also a tree farm, has proposed a devastating prospect for Parley's Canyon. There is overwhelming opposition to this proposal, and as a mom, I'd ask you to address this issue and realize how much pain you have caused our community by entertaining the idea of a new mine this close to our communities and our children. It is time for this to end, and it is also time for the division to issue a moratorium until the division can upgrade the policy for the mines in the Wasatch. This is the public harm. There is no clean way forward. I have put this in the chat and make record of it for Julianne. Thanks.
Okay, thank you. Paul, have you seen anything else come across your?
Dr. Chappell, not sure if he was the last one.
He's had an opportunity. He just needs to turn off his hand.
I see Katie Hedman is our last commenter.
Yep. Katie Hedman, please go ahead.
Hi, I'm Katie Hedman. I wanted to speak on behalf of the full-time residents in Mount Air Canyon. I live here full-time with my family of 4. As you can see, I'm home now with one of them, and I feel that this mine is really detrimental, not just to our homes, but the whole Wasatch Front, and why we live in this beautiful state of Utah is to be able to come and enjoy the outdoors, and I would hate to see that be ruined. Thank you.
Thank you. We'll move on to Nate Gibby.
Hi, I'm Nate Gibby. I'm a member of the Canyon Rim Citizens Association, as well as the founder of Canyon Rim is Community, which is a local grassroots community service organization based here in Canyon Rim. I just want to echo what Councilmember Jackson said earlier about the impact of those of us who live right in the mouth of the canyon. Justin Wild, who was also on this call, provided a study that found that with a 10-mile-per-hour wind, particulate matter of 5 microns can travel up to 4.5 miles, and when dropped from a height of 16 feet, which of course puts our neighborhood right within that perimeter. So we would ask anything we can do to not only prohibit another mine from going into the canyon, but also if we could take a good look at I'd request that we take a good look at the existing one in there, because as Councilmember Jackson mentioned earlier, too frequently our homes and our cars are covered with dust, let alone the impact that would have on the health of our lungs. I'll leave that with you. Thanks so much.
Thank you. Paul,
Chairman, I believe that concludes. We do not see any others reaching out for technology assistance at this time.
Great. Well, thank you. Appreciate the comments. I think that at this point, it's up to the board to deliberate on these matters, I should say. We have a decision board to make. It is what? 12:17. We have a working lunch scheduled. So we have a choice. Do we want to deliberate on these matters now and come back? Or do we want to deliberate after lunch and after our evaluation of the environmental award, excellence award? Any preferences from the board? Oh boy. You want to deliberate on this matter and come back and then break for lunch?
But I don't know how hungry everybody is. It'd be nice. answer
I would agree with that.
if we can do it in 10 minutes.
I'm not sure I'd put a time limit on it, but
15.
why don't we, why don't we go ahead and deliberate on these matters and we'll come back and have a decision. We'll go off the record. Thanks.
Mr. Chairman, the recorder has been started again. You're welcome to proceed at your pace.
Okay, thank you, Paul. Michelle, you're ready? Great. We'll go back on the record. Again, this is the tree farm matter. We've deliberated, excuse me, and have considered the requests. And I believe after having deliberated, we're ready for a motion.
I move that we grant the stipulated motion for dismissal and deny the division's motion for policy guidance.
I'll second that.
Discussion on the motion.
Mr. Chair, I anticipate that in the board's order that there will be some guidance for the division.
Okay, thank you. Any further discussion on the motion? Then we'll put it up to a vote. All those in favor say aye. Aye. Those opposed? Hearing none, the vote was unanimous. The board's Attorney General will prepare the order. I think that settles this particular matter. And what we will do now is we will go ahead and break for lunch, have our working lunch meeting with the board and the division members that need to be present for the working lunch. We'll do it in the board break room, and we will come back at 1:45 and resume. Any problems with that for the upcoming matter? Great. We'll go off the record. Thank you.
Now live again.
Okay, thank you. We're here this afternoon in the working months to consider a environmental excellence award nomination put in by Liberty Gold, Gold Strike Inc. And I'm going to turn the time over to you, Ollie.
Okay, great. Perfect. Well, as you mentioned, we did receive only one Environmental Excellence Award nomination this year. So, and it's for our minerals program. And so I've actually, Dana Dean, who is Deputy Director over the minerals program, will kind of review that. And I think that's usually what we've done is have her speak about that and recommend. So I will turn the time over to her now.
Thank you.
Yeah, so this nomination was made by Ken Coburn, who began with this one of bonding to the engineering program. It's the pilot Gold Strike Liberty Gold operator. They're doing a bunch of exploration down in the northwest corner of Washington County, and she has nominated them for their use of GIS. Not only in what they do, but in sharing that information with the division. This doesn't really go above and beyond what they're required to do. So we were sort of on the fence of whether to even bring this to the board. But it is, the good thing about it is that their sharing of information helps us when we're doing our inspections of either operations or reclamation. Their extensive sharing of the information that they gathered with GIS helps us with both of those processes, and it helps us also to be innovative within our own, we learn things from them that we can use in the division. So don't really go above and beyond, but Kim was very appreciative of the help that they give her as an inspector. And we thought the board to decide whether to hear more or not, but they are a good example of the other operators and cooperation and sharing data with the division.
Have they done anything good? How they do in the real world as far as their?
Oh, they do really great. They've done great reclamation, but again, nothing above and beyond the rules in any way. But they have done good and efficient exploration. Reclamation of their station.
So Dana, does the division require operators to share their GIS information?
No, our rules are outdated on that. There are some rules that say, that you can ask for other information as desired, but a lot of times we haven't gotten that information. So our rules don't really say they were before this type of stuff are available. And anyway, it's kind of a toss-up. We let the board decide whether to hear more or not. It's very complimentary of the company's work that they've done, both with reclamation and with sharing this information. And again, another thing that we benefit the division has gotten from it is you implement some of the things ourselves that we've learned from as far as the GIS, using GIS.
Sure. Has Kim reached out to the company?
Yes, I can answer. Yeah, she's been in touch with the operator and they've been asking, and they said they would be prepared to come in and give a formal presentation if the opportunity arose. So they are aware of, and they did kind of help and review her nomination. So
Was this an economic mine and they did well on it? And now they're just
It's
proportionally.
exploration so far.
Oh, it's just exploration.
Yes, yes, yes. So
But they're having to reclaim some
yes,
behind their
so
exploration.
they're trying to exploration. Yes, yeah.
But they're in a little mining district.
Right. And so they're exploring in an area where mining has occurred in the past. They're thinking that their updated techniques they may be able to find economic mineral, but that right now all of them is exploration.
got gold strike in their name. So
Yeah,
that's it.
yeah, yeah.
That's being positive.
They're definitely a gold mine.
That works on some investors.
Oh, I just heard questions. Oh, there you go. Questions? One question was, what type of, have they done any mining? So I said, no, they haven't done exploration, but they've done some good.
So this is at a historical, this is a mine that failed in the early 90s. And what this company does is they buy mines and they properly explore them. If there's viable material, then they go to the mines. They're going to be putting in a large mine plan with us later on this year to do all the background studies for the done. They have done other projects in Nevada and other places. They have one going on right now in Idaho. And they do all their exploration right, where right now they're just actively exploring this and taking what they've learned over from Nevada over here. So they will not, they haven't mined yet, but they will. There's over 100,000 ounces of gold there. Or sorry, 1 million ounces of gold there. They're going to be mining 100,000 a year. It's a 10-year mine.
The current prospect.
Yep.
But you can, nothing they've done is above and beyond what's required by the rules, or do you feel like they have exceeded the rules?
They have the best reclamation I've seen here in the state. They, what I consider to be average and stuff, they like, no, that's not ready yet. And I'm like, no, this looks great. No, it's not. Wait a little bit. So they deliberately a lot of times just look at stuff and say, I know this has only been here for 3-4 years. We're not happy with it, so let's wait on this one. With this GIS program that they've implemented, they know exactly how much vegetation on every single pad. And going, these are the ones that are above our requirements. These are the ones that are below. And they dynamically go through and evaluate them every couple months. It's a living database that they're constantly working on and improving.
So essentially, if they're going to check in every 2 or 3 months, that's above and beyond.
Yeah, yeah.
Here's what I'm struggling with. And it's not necessarily this application, it's that this is the only application that we've received this year. And I want to make sure that if we're going to keep this program, that it's, I would say it's appreciated. And that it actually means something. And I know in the past that we all voted on some maybe not everybody agreed on, but should have gotten awards, and some that maybe should have didn't. But I'm kind of like to raise the interest in this program again. And I was hoping that we would have a really great set of nominations that we could out. I'm not sure if this is the one, but I'm also not saying that
Bus GIS program I've seen in the state. And I blatantly borrowed from them for other operators in developing our own data standards. Where they have taught me a lot about how to be able to manage a large term exploration projects and what's even in the different fields. So I've always thought they've gone above and beyond, and this was the first year we've actually released a couple of what they've actually done. We've actually had final successful reclamation, which is why I waited on this. I just did not know that there wasn't going to be any other interest, where this one is to see what they've been doing on technology, where it's not just one avenue, they're doing everything. They're doing drones, they're doing LiDAR, they are going out there and walking it, to constantly working on it. They're using every single latest bit of the latest technology to be able to get the best product possible. They're getting satellite imagery from military. They're just doing everything they can to constantly keep improving.
What about on the ground? Are they doing anything innovative? How to handle topsoil or seed mix or
Part of the seed mix and species, this area, because we're kind of mighty, they know what works and what doesn't. So they're going through and fine tuning it. But one of the reasons why they walk so much is that area is so parked for water. They don't get a lot, so they kind of go through and evaluate, okay, this area needs seeding, and then as soon as it starts to have a forecast for rain, they go out there and seed. But they are trying to make the best possible seed. And they install weather stations too, to start collecting that data as part of the data. Like they're
yeah, so they're starting. They're applying. It's not just a data management thing.
Yeah, they're applying
good. It's they're applying. They're using that to change how they behave.
Exactly.
For the good of
part of this should have been written about.
Yeah.
Sorry.
But part of the discussion is to find out, you know, what are they doing, and if they were to come and present to us, what more can they tell us that shows they're going above and beyond? Or does it agree with that?
Yeah, and then also, I mean, when you're describing them, they have more motivation than just, we're just doing this because we have to. You know, we're just looking for gold. It sounds like they care. And that's what would be fun to hear, you know, hear from them and why. You know, why do you care so much? Because this isn't where they live, right? They don't live anywhere, I don't know where they're from, but.
They live all over the place. One of them is in Salt Lake. Most of them are in Reno and Nevada.
Yeah.
It's one where one of the reasons why they care so much right now is they're developing a large mine plan.
Yeah.
They're putting in the effort for years worth of studies beforehand, where the earliest they see themselves mining this is in 2025, if everything goes well. But they're like, yeah, we're in it for the long haul right now. They've been actively exploring and finding more and more ounces of gold, and they want to make sure before they actually start doing it that they're not putting gold. Like part of the failure of the last mine is they put their heap leaches, their tailings on top of viable deposits of minerals. Exactly. They forgot to have it. So part of the plan is they're going to go through all the old tailings, all the old heap leaches, and get all the gold that was mixed beforehand. They're developing these very robust plans.
So do you feel like they're raising the standards that other operators would try to do?
Yes, they definitely are raising the standards. They are so transparent with their data, they regularly share it with us. And they even have other data that's not related to reclamation. They've shared hazards that they found. There's over 68, this was an old historic mining area with a couple thousand people in it. They found all these hazards around, saying, hey, there's an opening over here, or this is a shaft that goes on 60 feet. It's not part of the whole disturbance, they're just logging it. And we're developing projects with our AMR team to go out and start addressing them. But it's one of those where they have all this data. They're not only using it for the reclamation, but everywhere else to inform their assets.
Do they have an ongoing core program?
Yes, and in fact, there's going to be sonic drilling this year. They're starting next month. But they have an ongoing drilling program where they're pulling it all out. That way they can develop the best economical mine plan. There's a lot of gold everywhere where there's different levels, but they're only trying to get the easy stuff.
I think if they do present, I'd like to see them kind of explore the angle of how they're using the data to improve their on the ground performance, not just the fact that that's good data. Yeah. I think that would resonate more.
Board members, would you like to
Definitely. Yeah.
hear more?
Because you know, from what you're describing, it sounds like this is the kind of miners we want in Utah.
Yes.
So, you know, that's want to hear from them. What's their motivation and what are they? Because there's a lot of satisfaction in. I learned how to prune a tree last week. I never pruned one. You know, you just when you're. It sounds like you know they're helping you in your job and not just to hope they get by and get a larger, you know, permit to mine, but to take care of the land. So.
Well, like Jim can answer this question better than I did.
I'm just very familiar with them. I remember one of my first impressions was they were so embarrassed by They turn in the annual report to us, and then a month later, they're like, we're sorry, we just got all of our line art and we fixed it. We have to go and do this corrective report. They're still well within their permit boundaries. They're like, we forgot about this little part of our disturbance and other ones. Like, they wanted to correct it and fix these records. And I'm like, you could have just searched it next year or not done this, or they went and sat down and met with us. They're developing all the background studies right now. And they're hiring the right consultants and they're going through all the steps and asking the right questions.
So they're doing good baseline work to prepare for an environmental impact.
Yeah.
Do they have,
supervision.
do they have active ongoing operations in Nevada? Are they actually producing the minerals in Nevada?
It's my understanding that it got sold when they started mining. It got sold to another larger producer. But I would not at all be surprised. They've been around for a long time.
So, I'm hearing this is going to like to have them come back. Next month,
It would be next month, yes.
have them come back if we have next month and concentrate on a little bit more of how they're going above and beyond. And what it is they're doing and how that benefits the environment.
I'll make sure to make that to them and also send them these links so that they can watch. Like just how much that they've gone and really consolidate, minimize the impact has been so impressive.
And we'll ask them to present next month.
Yes.
I don't know if you have to vote on it. It sounds like everybody's yeah. So that's what we do. So, and then come next month.
Okay, I will send them a letter, get it arranged.
Okay, thank you.
Okay.
Can you turn off the public part of this thing? I'm an ugly eater and I don't like it.
I ate before I came in here, so.
I've been eating the whole time.
Does that?
Right.
I'll tell Paul. Okay.
Okay. Well, thanks, everyone.
Thank you.
Mhm. Didn't really do too much, but thanks for your time.
Well, we'll see if we can continue this program. If we get the same kind of, I shouldn't say, bills, if we get a lack of interest, we may think about doing something.
If we have something going on,
Get some direction.
I think it's disappointing. Yeah. We have one nomination. Yeah, Kim had to do it.
And how many, I mean, I feel like we normally go through 5 to 10.
Yeah.
So,
It seems last year, I think we had at least 5.
yeah.
So, and where's Galecki this year?
Yeah.
We've been so overwhelmed.
Okay, I was gonna say, normally, he's a champ every year, and he's there, so. I thought, wow, things must have really.
Yeah, they've been so overwhelmed. They really didn't have a project that was all. Yeah. Oh, sure. So just ask you to go ahead. Paul, go ahead. Paul? I'm kind of hungry.
You just drop kick that thing in the middle right there. Just absolutely
Put it under,
No.
wrap it in a blanket and put it in.
No, but I think that I would like to see, as you said, some resurgence of the appeal of this.
Yeah.
I don't know what we can do to be pushes.
How is it promoted? Companies out in the basin know what's going on? Or?
Yeah, we have, that's another thing too, is there's so much turnover in industry that's like, an email that worked last year may not work this year. But I know that Utah Mining Association and Utah Petroleum Association promote it on our website, and we send out the letters. So,
Maybe we could ask the associations to help out.
Muted.
Oh,
Ready now.
Okay.
Mr. Chairman, we solved our technical issue of being self-muted. if you're okay and the working lunch meeting has concluded, we'd like to stop the recorder if I could receive your permission.
That would be great.
Excellent. We show 25 minutes until the board meeting resumes. We'll transition back to the countdown clock for those watching on YouTube. Thank you, Mr. Chairman.
Thank you.
So hasn't the lieutenant governor come through the work done?
Governor Cox came and ordered it.
But it was before he was governor.
Yeah, right.
It was lieutenant, but we have him.
And there was Grant Hughes that came one year.
I believe we're ready to go back live on our YouTube channel. Division. Mr. Lyons, is the division ready to go on this next item?
Sure.
Okay, we'll go back on the record. We are going to be hearing, let me make sure I'm on the right page here. Item number 4, docket number 2022-004, cause number 996-01, in the matter of notice of agency action by the Division of Oil, Gas, and Mining seeking an order forfeiting the reclamation bond provided by Tidewater Oil and Gas Company LLC for reclamation of the subject wells and other related relief. At this point, we'll turn the time over to the division for appearances of counsel.
So Charles Lyons with the Attorney General's Office on behalf of the division.
And I see nobody else is here. Nobody from Tidewater is representing them. So proceed.
Sure. So the division filed a notice of agency action against Tidewater Oil and Gas Company LLC on February 10th, 2022, which included 3 causes of action: refusal or inability of the operator to conduct necessary reclamation under Utah Admin Code Rule 649-3-116. Cause 2 was noncompliance with permit conditions issued by the division under Utah Admin Code Rule 649-3-116 also. And then the third cause of action being requesting authorization to recover all costs of plugging and restoration in the event of insufficient bonding under that same rule. So in support of the division's notice of agency action, the division filed exhibits on February 22nd, 2022. Respondent Tidewater did not file a response, and therefore the division filed a motion for entry of order of default on March 14th, 2022. As he just stated, respondent Tidewater is also not present at this hearing, and therefore the division would like to make its motion for an entry of an order of default at this time.
Got to turn it on. Board members, I believe there's a motion that's needed to approve the request by the division. Anybody want to make that motion of for the perhaps could you restate what you need us to say in the motion?
Just to order this as an entry of order of default. Yeah.
Great. Anybody want to make that motion to?
Can I
Gordon?
say so moved, or do I need to restate it?
I think that's all right to say so moved. Is there a second?
Second.
Discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Hearing none. The vote was unanimous. I will sign it. So go ahead with anything else you'd like to present.
Okay. So I just kind of want to educate the board a little bit, I suppose, on these default motions. The way that the board's rules and the Utah Administrative Procedures Act is written, says after issuing the order of default, which we just voted on, the board shall conduct any further proceedings necessary to complete the proceeding without the participation of the party in default and determine all the issues in the proceeding. In the past, the division and the Attorney General's office has kind of presented almost a full hearing. The division believes that is a little bit overboard and not necessary for the purposes of these, but I did just want to give a brief summary status of kind of why we got here for your knowledge. So these wells, there's 5 subject wells. 3 of them really never reported any production. Others had minimal production, stripper well production levels. Tidewater is a company that went through Chapter 11 bankruptcy almost a decade ago, has expired business registrations in Utah and Colorado since 2018. And this is simply a case of needing to reclaim, plug and abandon these wells where bonding is posted, but essentially nobody left to take responsibility to do that. And so it's almost a procedural formality to request the board to get this bonding money, give it to the division and clean this stuff up. If you have any other questions that you feel this proceeding requires in order to settle all the issues, I would move that all of the division's exhibits that were filed become part of this record. I don't know that we necessarily need to go through all of them for this, but to just take perhaps administrative notice of that, or to add them into a proposed findings of fact, conclusions of law and order, however we want to do that, because that serves for the basis of entering this order.
I think we can do that.
Yeah. So if the board has any specific questions, I can address those, or I will just go ahead and make my motion to ask the board to grant the relief requested.
Board members, do you have any questions? Sure, Mr. Church.
So, Mr. Lyons, where do we sit as far as the bond monies adequately covering all the work that's going to be required? Is there any estimate there?
The estimate is that it should be fairly accurate, the amount of money that is available for these wells. These are all full cost bonding wells. None of this was under a blanket bond. So technically we should be there, give or take. You never know if there's any difficulties that come up when you actually do this kind of work, but the division is fairly confident that this is enough money to do the work required.
Same question.
Okay, thank you. I don't know other questions. Go ahead and
Sure.
sum up.
Yeah, in sum, I mean, the division is simply asking the board grant the relief requested in the division's notice of agency action, that the individual well bonds held by U.S. Bank and the treasurer be forfeited and released to the division, that the board authorize the division to use the forfeited funds to complete the plugging and restoration of the subject wells, that the board authorize the division to take any additional action if necessary to recover any funds required that may be in excess of the forfeited funds, and to grant further relief, that the board deems just and proper.
Thank you. Board members, any questions or concerns? Sure, Ms. Garrison.
Have you checked with Sitla to see if they have any bonding money? I believe they were surface owner on some of those wells.
I don't know if they have any bonding money. I do know that mineral leases were canceled in 2018, and I did receive an email from Sitla just saying that they would be watching this matter closely. So I don't know specifically. They didn't raise anything. They didn't file a response or want to participate in this hearing. So I don't have the answer to that question.
You might contact them and see if there's any additional funds available to add to your money.
That's always a good option.
Any other discussion or questions? Well, the matter before us, I think, is the division is asking us to vote on their request for relief. Does anybody want to make that motion?
I move that we grant the relief requested by the division.
Is there a second? Second. Any discussion? Hearing none, we'll take a vote. All those in favor say aye.
Aye.
All those opposed? Hearing no opposition, this passes unanimously. I assume you'll prepare the proper documents.
I will. Thank you.
Thank you. All right, we'll move on to the next and final docket item. Oops, maybe not. Sorry. Okay. Docket number 5, I'm sorry, agenda item number 5, docket number 2022-005, cause number S/003/0049 and M/003/0050. This item has been continued until next month. Is that correct, Division? That everything is set for next month on that?
That's correct. And just to inform the board, working on a stipulation and agreement to allow the operator in that cause to do the reclamation work themselves. And the only reason why it got continued is because we couldn't sign these documents and get them finished before this hearing. So it should be relatively quickly, if not by the end of this week, early in next week.
Okay.
Yeah.
Thank you. All right. Agenda item number 6, docket number 2022-006, cause number 470-05, in the matter of the request for agency action of Finley Resources, Inc. et al. I will not read the entire paragraph because I think this, everything that will be discussed will come out in this presentation. So when you're ready, we'll take appearances of council.
I can start. This is Haley Souza for the Division of Oil, Gas, and Mining with the Attorney General's Office.
Thank you, Haley.
And my name is Artemis Vamianakis from the law firm of Fabian Van Cott on behalf of petitioners Finley Resources, Inc. and Finley Production Co. If you just give me one moment to hook up my computer and we'll be ready to go.
Okay. Do you have witnesses today?
I do,
Okay.
Mr. Chairman.
Thank you.
It is not showing up on the screen just yet.
Well, Paul, can you help us out?
They did, yes.
We'll go off the record for a moment, Michelle.
There it goes. Thank you so much.
You ready? We'll go back on the record, Michelle. Please introduce yourself again. I'm sorry, and then we'll swear in your witnesses.
Thank you, Mr. Chairman. Again, my name is Artemis Vamianakis from the law firm of Fabian Van Cott on behalf of Finley Resources, Inc. and Finley Production Co. With me today is Mr. Scott Pitzer, Manager of Land and Business Development of Oil and Gas, the Oil and Gas Landman of Finley Resources, Inc. Mr. Shay Atkins is also here with us. He is the Geology Manager of Finley Resources, Inc. And Patrick Porter, the Exploitation Manager and Reservoir Engineer of Finley Resources, Inc. If I may ask that the court reporter swear the witnesses in at this time.
Will you each raise your right hand? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Please proceed.
Thank you, Mr. Chairman. Mr. Chairman, ladies and gentlemen of the board, the resumes of the witnesses that I just presented were collectively submitted as petitioners Exhibit A. And if asked, each will confirm that the information reflected in their respective resumes is true and correct. Today, Mr. Pitzer will be testifying as a fact witness only. Mr. Shay Atkins has previously been recognized by this board on several occasions as an expert in geology, most recently in July of 2021 in cause number 470-03. among several others. And presuming there's no objection from the division, we would so move that he be recognized as an expert in geology in this cause as well.
Division,
No objections.
board members, any objections? Hearing none. He's accepted as an expert witness.
Thank you, Mr. Chairman. Mr. Pat Porter has also been previously recognized by this board as an expert in reservoir engineering on several occasions, most recently in February of 2020 in cause number 470-01 and cause number 600-01, among several others. And similarly, presuming no objection from the division, we would ask that he be recognized as an expert in this cause as well.
No objection.
Board members, hearing no objections, he'll be recognized as an expert witness in this matter.
Thank you, Mr. Chairman. And before moving any further, I'd just like to confirm we would like to have all of the exhibits admitted at the end of the presentation, if that's acceptable.
Yes, please.
Thank you. And one last housekeeping matter. We have Finley Resources and Finley Production as the petitioners. I will be referring to them collectively as Finley. Finley today is seeking approval from the board of several measures which will allow for further development of the Lower Green River Wasatch formations through long lateral horizontal wells in certain sections within Township 4 South, Range 1 East in Uintah County. The relief Finley is seeking today is similar to relief that this board has granted in other recent causes in the area and is designed to maximize resource recovery, prevent waste, and protect correlative rights. Specifically, Finley requests that the board grant the following relief. First, Finley requests that the board establish drilling units for production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations, as have been defined in our request for agency action, through long lateral horizontal wells comprised of sections 13 and 24, 14 and 23, 15 and 22, 16 and 21, 25 and 36, 26 and 35, and 27 and 34, respectively. In Township 4 South, Range 1 East in Uintah County, and those lands have been defined in the request as the subject lands, and you may also hear us refer to them today as the application lands as well. Finley requests that the board establish these drilling units to effectively reduce the available oil in place within this area, which we refer to as the Leland Bench area, and that the board authorize the drilling and production of up to 20 horizontal wells per drilling spacing unit. 4 of the proposed units within the subject lands are 1280 acre or substantial equivalent units for long lateral horizontal wells within 1324, 1422, 1423, 1522, 1621, and those are the units that we refer to as the 1280 acre units. 3 of the proposed units are a little bit smaller, so we've defined them in the request as the special acre units. Specifically, sections 25 and 36 are approximately 1230 acres. Sections 26 and 35 are approximately 1180, and sections 27 and 34 are approximately 971 acres. To Finley's knowledge, there are no existing horizontal spacing orders covering the subject lands that pertain to horizontal well development. There are 2 existing orders that cover portions of the subject lands. The first is the board's order entered on May 12th, 1997 in cause number 239-01, which approved the Enhanced Recovery Project by water flood for the Leland Bench area, and that covers the portion of sections 23, 25, and 26. And the second existing order was the order entered on December 22nd, 2014 in cause number 239-03, and that established certain drilling units for vertical wells. And that again covers portions of the subject lands, including sections 13, 16, 21, and 22, and a portion of section 27. Neither Order 239-01 nor Order 239-03, however, pertain to horizontal well development, and petitioner's request does not seek to modify or alter those existing orders in any way. Petitioners submitted both of these orders, order number 239-01 and order number 239-03, as its exhibits B and C respectively in this cause. In addition, the requested drilling units are supported by precedent, as the board has approved similar units in its order on August 7th, 2017 in cause number 131-51. 151, modified and extended by the board's order in cause number 470-03 in Township 3 South, Range 1 East in Uintah County. The second item of relief that Finley is requesting from the board today is that the board allow for reduced setbacks within the 4 proposed 1280 acre units and within the 3 proposed special acre units, such that the north-south drilling unit setbacks are reduced from 660 to 100 feet, and the east-west drilling unit setbacks are reduced from 660 to 330 feet. The requested setbacks are also supported by precedent, recent precedent from this board. For example, the board approved the same setbacks in its order in cause number 470-03, again within Township 3 South, Range 1 East, and in cause number 600-01, and I believe 600-03. Mr. Porter and Mr. Atkins will also be providing the technical justification for these reductions as well within the subject lands. The third item that Finley is requesting in its request for agency action before this board today is that the board establish overlapping drilling units through internal drilling unit boundary long lateral horizontal wells along the internal boundaries of these proposed 1280 and special acre units within the subject lands. The requested overlapping drilling units are similar to those approved by the board, again in cause number 470-03. And the board has previously and at that time recognized the efficiencies gained by concurrent drilling, provided that the wells in the underlying 1280 drilling units are producing prior to the drilling spacing unit boundary wells. To that end, as part of this request, Finley has proposed certain conditions that are similar and nearly identical to the conditions imposed by the board in its order in cause number 470-03, and as amended recently by the board in cause number 470-04 on February 10th, 2022. The specific conditions are set forth particularly within the request, but in brief, the first condition would be that the north-south setbacks from those shall be 100 feet from the drilling unit boundaries. No long lateral horizontal well shall be within 100 feet in vertical depth from another long lateral horizontal well, and the long lateral horizontal well shall be 100 feet on either side of the internal east-west drilling unit boundary line between the 1280 acre units and the special acre units. In addition, the next condition would be that the surface location of said wells not only may be located anywhere on the drilling unit, but may also be located off the drilling unit so established, presuming proper authorization for such location has been obtained from the owners, and the well will be cased and cemented to the 100-foot setback. The third condition would be that no such internal drilling unit boundary well may be drilled unless at least one underlying long lateral horizontal well has been drilled and is producing on each of the adjacent 1280 or special acre units comprising the drilling unit boundary, the drilling unit for the internal drilling unit boundary wells. Or as an alternative, that no internal drilling unit boundary well shall produce until the 2 underlying overlapped 1280 acre or special acre units are held by production as to all acreage within the long lateral horizontal wells, meaning that the contemporaneous drilling of an internal drilling unit boundary well is allowed if the adjoining long lateral horizontal well will be producing in paying quantities for at least one full day before the internal drilling unit boundary well produces. And all of those aforementioned conditions shall be evidenced and verified as particularly described in the request. And that evidence and verification is nearly identical to that which was recently approved by the board in cause 470-03 and 04. The board has jurisdiction over these matters pursuant to Utah Code annotated 40-6-5 sub 3B and 40-6-6. As Mr. Pitzer will testify a little bit in a moment, notice was sent via regular mail to all production interest owners in the requested drilling spacing units, to all working interest owners, including unleased interest owners, and the working interest owners within the larger Greater Monument Butte unit in sections adjacent to the requested drilling units, and to the Bureau of Indian Affairs, being the governmental agency having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last known addresses based on a reasonably diligent search of Finley's internal records, Uinta County deed records, searches conducted by brokers in Uinta County Basin based on deed records, and various website searches. Many were returned as undeliverable, but any that were returned with forwarding addresses or any updated addresses that could be located, as soon as we located updated addresses, we turned around and sent out those papers to those parties as best we could. The record will also reflect that notice was duly published in the Uinta Basin Standard and Vernal Express on May 2nd, 2022, and in the Deseret News on May 4th, or pardon me, I may have said May, let the record reflect it's March 2nd, 2022, and in the Deseret News on March 4th, 2022, and in the Salt Lake Tribune on March 6th, 2022. The division did not file a staff memorandum in this cause. No responses were received, and importantly, no objections were received or filed in this cause. With that, Mr. Chairman, if I may, I would like to begin my examination of Mr. Scott Pitzer.
Please proceed.
Thank you. Mr. Pitzer, would you please state your name and business address for the record?
Yes, my name's Scott Pitzer, and our business address is 1308 Lake Street, located in Fort Worth, Texas, 76102.
And what is your current title and position?
Manager of Land and Business Development for Finley Resources, and I have supervision over this area.
And would you please state for the record the corporate and bonding status of Finley Resources, Inc.?
Finley Resources, Inc. is a Texas corporation with its principal place of business in Fort Worth, Texas, and is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies.
Would you please also state for the record the corporate and bonding status of Finley Production Co.?
Finley Production Co. LP is a Texas limited partnership with its principal place of business in Fort Worth, Texas, and is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies.
And would you please also state for the record the relationship between Finley Production Co. LP and Finley Resources with respect to this cause?
Yeah, Finley Production Co. is a working interest owner or the owner of the actual leases in the subject lands. And Finley Resources is the operator for and acting on behalf of Finley Production Co.
Thank you. All right, Mr. Pitzer, I'm going to now direct your attention to some of our exhibits. You'll see them displayed on that screen or here on my computer screen here. First, I'm going to direct your attention to exhibits petitioners exhibits D through M. I will scroll through them a little bit quickly just to make sure. And I'll ask you now if you recognize exhibits D through M.
Yes.
And were exhibits D through M created by you or someone at Finley with under your supervision and approval?
Yes.
Great. So now turning specifically to Exhibit D, Mr. Pitzer, would you please explain and state to the board and the division what this exhibit shows?
Yeah, this is our locator map. We call this area Leland Bench, and you can see it outlined in red down in the kind of the bottom right corner of your screen, and you can tell that it's southeast of Ballard City.
Great. And would you mind pointing out what is outlined in brown there on that exhibit?
Yes, so each brown rectangle that you'll see there within the red outline are the proposed 1,280 acre units or the special acre units.
Now, Mr. Pitzer, I'd like to turn your attention to what's been marked as Exhibit E. Would you please describe what Exhibit E shows?
Yes, so this shows our application lands, again, just zoomed in, and it also shows the 1,280 acre drilling and spacing units comprised, and you can tell that section 16 and 21 is a unit, 1522 is a unit, 1423 is a unit, and 1324 is a unit. So that would be your top row of rectangles there, and those are all about 1,280 acre units. And then if you look at the bottom row of there's two sections each. We call these our special acre units. And as you can see, 2734 is a special acre unit. It's comprised of about 971 acres. 2635 is comprised of about, what does that say? 1180?
1180.
And 2536 is another special acre unit. And we just call these special acre units because they're comprised of less than 1,280 acres.
Great. And is this within Township 4 South, Range 1 East?
Right, 4 South, 1 East in Uinta County.
Thank you. All right, Mr. Pitzer, now turning your attention to what's been marked as Exhibit F. Would you please describe what Exhibit F shows?
Yes, this shows our notification area. So our application lands, again, which is outlined in red. Every production interest owner was notified within that area, and then the dashed brown outline would be the notification we sent to all working interest or unleased mineral owners. And the reason you see it expanded a lot below is because that's actually a very large unit called the Greater Monument Butte unit. And in order to properly notify, we would have had to notify everybody in the unit. So all working interest owners within that unit were also sent notification.
And can you please describe briefly the procedures that Finley followed to obtain the names and addresses of all of these parties that were notified?
Yes, so started out with our internal records since we already operate on many of the sections within there. So we already know who the owners are in a lot of the internal application lands. And then we go to the deed records in Uinta County's clerk's office and get the last address of record. We do that in-house, and we also use brokers who are local to the basin to help us with that. And then also if, and last case scenario would be to use various internet websites, one of them being TransUnion.
I'm going to ask you to refer to a few documents we have submitted in this cause. The first being the certificate of service, the second, the supplemental certificate of service, and the third being the second supplemental certificate of service. I've placed them here in front of you. Again, these pleadings were prepared by my office, and we submitted them and filed them in this cause. Do you recognize the names and addresses shown in those documents, Mr. Pitzer?
I do.
And who are those parties listed there?
They are the interest owners that I was just describing within the space lands or adjacent lands. They're the parties that received notice, and as I just mentioned in Exhibit F here.
And were any of these addresses ever updated, to your knowledge?
Yes, if they came back or if we were able to locate an updated address, we would have sent notices out to those updated addresses.
To the ones where we could find updated addresses?
Mm-hmm. Yes,
Great.
that's right.
And is that what is reflected in the supplemental and second supplemental certificate of service?
Yes.
Great. Okay, Mr. Pitzer, I'd like to turn your attention to what's been marked as Exhibit G. If you could please walk us through what Exhibit G shows.
All right, Exhibit G shows our red outline, which is our spacing, our application lands. And this is going to show you the two previous orders that are, that have been already put in place there, and they only affect the vertical well development. And today we're not changing anything. We're not changing anything with those orders that are already in place. Those are simply for vertical wells, and we're only changing the rules for the horizontal wells.
And can you describe a little bit of what that diagram on the right shows us?
Yeah, that was just trying to show the vertical wells being on top, and then you'd have your horizontal wells being on the bottom. There's not really a gap there. It was just trying to show that they won't affect each other.
And within that diagram is the red outline, is that kind of the application land similar to the red outline in the image on the left-hand side?
Right.
Great. And to be fair, this may be a question that will be best left for Mr. Atkins, but just because we have this great exhibit here and diagram here, to your knowledge, have any of those lands that were approved in, for example, in order 239-03, was that already approved for some reduced setbacks?
Yes. So the 23903, which is the blue outline, it has already been approved for 330-foot east to west setbacks, which is what we're asking for today as well. But we wanted to point out that some of these lands have already been spaced for that setback for vertical wells.
Thank you, Mr. Pitzer. And it's a better question for one of your colleagues, but since we had this great diagram out there, I just wanted to point that out, so I appreciate that. Turning now to what's been marked as Exhibit H, would you please describe what Exhibit H shows?
Yeah, this was showing the relevant spacings in the basin in Uinta and Duchesne counties. If you can see our red outline, that shape that you've seen now several times being our Leland Bench or the application lands, is kind of down in the southeastern corner of that. But we just wanted to show that this is in the vicinity of all the other spacings that have been going on throughout the basin over the last several years.
And this exhibit shows, it is admittedly hard to see, but hopefully on your paper copies, it looks like the various cause numbers for the orders that have already been entered are kind of depicted within that exhibit. Is that right?
That's right, yes. And
Okay.
the green dots are existing wells.
Great, thank you. Turning your attention now to what has been marked as Exhibit I, would you please explain what Exhibit I shows?
Yes, so this is showing what we call the external DSU boundary units. The plat reflects the 3 proposed external boundary units within the application lands, and they're outlined in blue. So you would have for these proposed external DSU boundary unit sections are going to be the larger ones. So if for instance, sections 16 and 14, 21 and 22 is a 2,500 acre external DSU boundary. So if you were to drill a horizontal well between section 15 and 16 and 22 and 21, that's where that unit would be. And the same goes for section 14, 13, 23, 24 would be another unit. And then section 26, 25, 35, 36 would be another unit. So the top two units would be roughly 2,560 acres, and the bottom unit would be 2,410 acres.
And now moving to what's been marked as Exhibit J. If you can please describe what Exhibit J shows.
This shows our proposed internal drilling and spacing unit boundaries. They're outlined in the blue dashes and shaded in blue. So you have 15, 14, 22, 23 is a unit, and that's about 2,560 acres. And then you have 27, 26, 34, 35, which is about 2,151 acre unit.
And now turning your attention to Exhibit K. Can you please describe what Exhibit K shows?
Yes, this shows the proposed overlapping DSU boundary units. It reflects all 5 proposed overlapping internal and external drilling and spacing unit boundaries. And it's basically just a combination of what we just showed you in exhibits I and J. This combination allows you to drill on every boundary line within the application land so that you're not leaving any reserves behind.
And just for the record, can you just describe how the boundaries external and how the external boundary units are delineated in the color versus the internal boundary units on this color code here?
Yeah, it's a little tough to tell, but so the external boundaries are the solid blue lines on the outsides of the application lands, and the internal DSU boundary units are the dashed blue lines and they're also shaded blue.
Thank you. Turning your attention now to Exhibit L, would you please describe what Exhibit L shows?
Yes, this is just showing you the wells that have already been drilled within the application lands. 102 wells have been drilled, and 2 of those wells are now saltwater disposal wells.
And the other 100, what kind of wells are those?
They're vertical producers, either shut in or producing.
And are there currently any horizontal wells within the application lands?
No, there's no horizontal wells in the application lands.
Thank you. Mr. Pitzer, I'm turning your attention now to what's been marked as Exhibit M. Would you please describe what Exhibit M shows?
Yes, we wanted to show that the Ute tribe owns almost all of the minerals located within the application lands. And just wanted to, we've provided notice to the Ute tribe and have had verbal discussions with them, and no objections. They've got no objections with our spacing. So we just wanted to show the board that the great majority is Ute tribally owned.
Thank you, Mr. Pitzer. Mr. Chairman, that concludes my examination of Mr. Pitzer.
Thank you. We'll turn the time over to the division to ask questions of this witness.
Yeah, Dustin Doucette for the division. Yeah, if you could turn to Exhibit G really quick. I don't know if this is going to be covered in future testimony or not, but just in regards to the spacing orders in 23903 and 23901, are those drilled below the Douglas Creek, or do you know that?
I'm going to defer to my colleagues back here. They'll be able to tell you that.
Okay. And so one of my main questions is there going to be a conflict with these drilling units, and specifically, I think in Order 23901, which is a water flood. I believe that is that spaced interval is Garden Gulch and Douglas Creek. Can you confirm this, or would that be for another witness?
Yes, I'll defer to my colleague Shay back there. He'll cover that.
Okay, so those are kind of my questions, whether there will be any interference between that water flood in particular and in that other order, the 23903 order, whether there's any conflicts between the horizontal development or not. It appears from here that you're going to develop the verticals shallower and the horizontals deeper horizons. Would you be able to answer that question if that's accurate or not?
I'll let you
All right.
answer.
Thank you.
I don't want to get
All
myself
right. I
in
got my
trouble.
questions on the docket here. So that's all I had. Thanks.
No other questions from the division? Thank you. Board members, do you have questions of this witness? Mr. Church.
Mr. Pitzer, in the special drilling units where you have internal and external overlapping, does it bring the occasion where you could have wells side by side that would have different ownership? Where you're drilling in an overlapping unit and horizontally, I can see some conflict there on ownership of the well.
Yeah, there could be. I'm trying to picture this in my mind. Each different unit will have different ownership.
So is there a protection correlative rights if you've got side by side wells that could be as close as 100 feet to each other, where you're pulling from one ownership into another one? Or do you have to, could you be producing both wells concurrently so there's not one that goes on production earlier and drains from the?
Yeah, that's going to be
correlative
covered. I'm going to defer to them. That they will cover that question as far as which one, the timing of production and how there won't be any conflict there.
Okay, thank you.
Seeing no other questions, turn it back over to you, Finley.
Thank you, Mr. Chairman. At this time, I would like to commence my examination of Mr. Shay Atkins, and I thank Mr. Pitzer for his testimony. And if the board would permit me, we thought, while I have Mr. Atkins up on the stand, sometimes there seem to be questions that are a little bit geology, a little bit engineering. So we thought that we might introduce both Mr. Pitzer and Mr. Porter and have them both here. And then, in case there's perhaps a question from the board or to the division, I will start and go through exhibits first with Mr. Atkins, but we thought it might be efficient to have them both up here in the case of questions, if the board would permit me that.
I don't think there's any problem with that.
Okay, thank you, Mr. Chairman. All right. I will start with Mr. Atkins. If you could please state your name and business address for the record.
My name is Shay Atkins. Our address is 1308 Lake Street in Fort Worth, Texas.
And what is your current title and position?
My title is Geology Manager of Finley Resources with supervision over our assets in the state of Utah.
And I'll turn also to introduce Mr. Porter in case, again, there are any questions. Mr. Porter, would you please state your name and business address for the record?
Patrick Porter, in our business, I'm exploitation manager for Fort Worth and also do the reservoir engineering duties. Our address is 1308 Lake Street, Fort Worth, Texas, 76102.
Thank you. All right, Mr. Atkins, I'll start with you. I'm going to be turning your attention to what have been marked as, for you, exhibits N through T. I'll flip through them just very quickly and ask, do you recognize exhibits N through T?
Yes, I do.
And were they prepared by you or someone at Finley with your input and review?
Yes, they were.
Great. Okay, turning specifically now to what's been marked as Exhibit N, would you please explain for the board and the division what this exhibit shows?
Exhibit N is a previously approved type log before the board, the Brotherson 1-11-B4 type log, and specifically calling out the application lands and section with respect to the Green River Formation, the TGR3 interval, the Wasatch, and then you see the Mesa Verde there on the left, and we will look at a zoomed in portion of this similar log coming up.
Turning now to Exhibit O, if you could please describe what Exhibit O shows.
So Exhibit O is a zoom in, an east-west cross section through the application lands. And a small note, a small typo on this cross section, the word Garden Gulch should read TGR3 to tie into the type log. So you can see that would say TGR3 through the Wasatch Formation. And you can see it in the east-west direction. Kind of going back to one of Mr. Doucette's questions earlier, you see on the right side of the cross section, the distinction of what we see as our development model being vertical development in the upper portions of the formations, and then horizontal development in the deeper portions of this section being the Castle Peak, the Uteland Butte, and the Wasatch Formations. These subject formations include a combination of low permeability siltstones, limestones, and dolomites with very high oil in place, but low recovery of the resource in a vertical well. And so therefore lending themselves to be better suited for horizontal drilling in order to maximize the resource recovery.
Turning your attention now to what's been marked as Exhibit P, if you can please describe what Exhibit P shows.
Exhibit P is a north-south cross-section, similar cross-section to the one before through the application lands. Also noting the horizontal versus vertical development on the right side of the cross-section. And also to note is the continuous nature and the consistency in the horizontal development zones, being the Castle Peak, the Uteland Butte, and the Wasatch. The vertical development zones are a little less consistent and lend themselves to be more effective in recovering resource vertically.
And just for the record, does this exhibit also, should Garden Gulch also be modified in this exhibit?
That's correct.
And what should it be changed to?
Garden Gulch should be changed to TGR3.
I'd like to turn your attention now to what's been marked as Exhibit Q. Can you please describe what Exhibit Q shows?
Okay, Exhibit Q has quite a bit of information, so bear with me. So this is a regional stress map of formation rock stress around the application lands. The arrows represent stress direction, presumably fracture orientation of hydraulically induced fractures around the lands using microseismic data as well as image logs and dipulsonic data around the area. And so this fracture orientation results in an average of north 85 degrees west. And we'll use that going forward on a couple more slides. At the top, the table that you see at the top is some microseismic data from the area in really two kind of project areas in very close proximity. One shown in gray from 3 horizontal wells with an average fracture half length of 252 feet. And then in light red on the bottom, 3 more horizontal wells with microseismic data with an average fracture half length of 239 feet. And so going forward on the next slides, we'll also use the 252 foot fracture half length, using the larger of the two for a little bit of built-in conservatism on our calculations.
Moving on to what's been marked as Exhibit R, if you could please describe what Exhibit R shows, Mr. Atkins.
So Exhibit R shows the current statewide spacing for a horizontal well, which would be 660-foot setbacks in the north-south and east-west direction of the toe of a horizontal well. You'll also notice that we're carrying forward the 252-foot fracture half length and also the north 85-degree west orientation. And so you can see in the tan, using those setbacks and those orientation and fracture half length, how much unrecovered hydrocarbon would be touched without reducing setbacks.
Turning now to Exhibit S, if you could please describe what Exhibit S shows us, Mr. Atkins.
So Exhibit S shows a similar depiction, but the scenario of the 100-foot setbacks at the toe of a horizontal well. And you can see in the upper right, where the trig for the calculation came from for some of the numbers that are on the diagram. But you can see using the fracture half length and that orientation, that with 100-foot setbacks, you would still be 78 feet with your fracture, the tip of your fracture length from reaching the offset operator. And so therefore, you're increasing your recoverable hydrocarbon, but you're also protecting correlative rights and not crossing onto someone else's lease.
Turning your attention to what's been marked Exhibit T, if you could please describe for the board what Exhibit T shows.
Sure. Exhibit T takes the same information and applies it to the east-west orientation and reducing that setback from 660 feet to 330 feet. It's a very similar calculation in the top right for reference, but this shows that reducing to 330-foot setbacks, the tip of your fracture wing would still leave 79 feet of conservatism to make sure that we're recovering as much resource as possible, but also not encroaching on correlative rights.
Thank you, Mr. Atkins. And based on your examination of the evidence and the data in support of this request and the exhibits presented, is it your expert opinion as an expert in as a recognized expert in geology in this cause, is it your expert opinion that the geology of the subject land supports the requested units for long lateral horizontal wells?
Yes.
And again, based on your examination of the evidence and the data in support of this request and the exhibits presented, is it your expert opinion that the data supports the proposed reduction of setbacks to recover additional resources?
Yes.
And is it your opinion that the setbacks would allow for additional resource recovery without adversely affecting correlative rights?
Yes.
And again, based on your examination of the evidence and the data and the exhibits presented in support of this cause, is it your expert opinion that the proposed drilling unit boundary drilling spacing units are supported and justified to efficiently drain the resource?
Yes, it is.
Mr. Chairman, that concludes my examination of Mr. Atkins.
Thank you. We'll turn the time over to the division for questions of this witness.
Yeah, Dustin Doucette again. I just kind of wanted to clarify, make sure I'm clear on the questions I had asked earlier on the vertical wells being developed in the area currently. I know it's your intent to drill future ones and complete them vertical wells down through the Douglas Creek. Is there existing wells that are producing lower than the Douglas Creek right now?
There are, yes.
And do you have any issue? Is there going to be any correlative rights issues with what you're requesting today with the horizontal development potentially going through those same horizons that are completed in those vertical wells?
No, sir. We don't believe there will be any correlative rights issues with that. We believe that there's a lot of resource not being recovered by the vertical wells in those horizontal formations. And so that's all the more reason in our mind to drill it and develop it horizontally.
And then as far as the horizontal, it's your intent to only drill below the Douglas Creek.
Yes, sir.
I think your request has the defined area as the TGR3 and below, but your intent or your request for horizontals is not the Garden Gulch or TGR3 down through the Douglas Creek. It's below that. That's correct.
Yes, sir.
Okay. Thank you.
Is that the sum of your questions?
That's everything. Thank you.
Okay. Board members, questions? Mr. Moon?
You have a prior 100-foot hill-toe setback spacing unit existing, correct?
Not within these lands.
But in other lands you
Yes, sir.
do. Okay, you've drilled some of those.
Yes, sir.
Have you kind of refined what you know now about, especially where you have a real flat natural fracture orientation? Because I mean, big picture, I'm looking at the S exhibit, and you see cushion, and we like cushion, but I see waste.
Right.
But of course we don't want to go we don't want to encroach.
Right.
But what are you learning from those 100-foot setbacks? Because most of your fractures going out,
right? Not. I think Mr. Porter was going to testify to some of that, but also I know other people have drilled, other companies have drilled wells that are say going in opposite directions from each other, even toe to toe, completing up to the 100-foot setbacks and not seeing any detriment to the quality of their wells. And so that's a piece of information that you're not seeing any interference that way.
Right.
But I think Mr. Porter's going to testify to some of the drainage in that direction as well. So at the end of the day, we agree we want to recover everything that we possibly can, but also make sure that we're not encroaching on someone else.
Yeah. So do you envision asking for even narrower setbacks at some point?
Not going to rule it out. It's hard to say for sure right now.
Especially where it's the same mineral owner too.
Right.
So if I'm the Ute tribe, I'm like,
that's right.
Get as close as you're comfortable. We don't want you fracks hitting each other, but
yes, sir.
Avoid that waste.
Mr. Church?
Do you anticipate drilling many of these wells from the same well pad?
Yes, sir. It's our specific intention to have multi-well pads. We prefer it that way. It's more efficient in a capital standpoint, and it's also more efficient in a surface disturbance standpoint. So for building facilities, for moving the rigs in, that's the most efficient way to develop it in our minds.
And with a special request for off-lease or off-unit surface locations, do you see many of those where you will actually be off the drilling unit and then as for your surface pad?
Yes, sir. I mean, I think that will be utilized. How many? I'm not sure at this time.
You don't see it as a big problem now?
No, sir, I do not.
Topographically?
No, sir.
Any further questions from the board? Hearing none, we'll turn it back over to Finley.
Thank you, Mr. Chairman. That will conclude our examination and the testimony of Mr. Atkins, and we thank him for his testimony. And I will turn now to examination of Mr. Porter, who has already been introduced. So we will go straight away to looking through exhibits U, V, and W. Mr. Porter, do you recognize exhibits U, V, and W?
Yes, I do.
And were they prepared by you or by Finley personnel with your input and review?
Yes.
Turning specifically to what's been marked as Exhibit U, Mr. Porter, would you please walk the board through what Exhibit U shows?
This slide is based on a calculation and an equation derived by Hale and Evers. It was developed in 1981, and it's basically describing the pressure transient and drainage away from a wellbore. And there is one typo on here in that horizontal target formation indicates minimal impact on adjacent lands. And I'll clarify that a little bit when we go down into the table, which shows basically a timestamp, 1 year, 1.5 years, 2 years through time. So you can see the advance of that drainage radius. And what you can see in the north-south direction, you'll see that it's over 6 years before you would exceed that 100-foot barrier. So I guess clarifying to the extent that, yes, eventually given infinite time, you will see drainage outside that drilling and spacing unit, but it offers more than sufficient time for offset operators to be able to protect their correlative rights. When we look at the east-west, we do not cross that line until over 40 years. So there's a significant amount of time before that pressure transient reaches the boundaries of the drilling and spacing units.
And just to clarify for the record, can you kind of point out in which column and which numbers you're referring to, the north, south versus east, west, Mr. Porter?
I'm looking at column BF, which describes the drainage in the north-south direction, and A sub F, which describes the east-west.
Turning your attention now to what's been marked as Exhibit V. If you could please walk the board through the information on Exhibit V.
A lot of words on this slide. Bottom line, trying to demonstrate how much waste there would be without approving this setback. We see by altering the setbacks to 330 east-west and 100 north-south that we would have an additional 1,120 feet of completed reservoir on a well, and that would equate to over 67,000 barrels of oil per well. The project itself is very economic. It's got a return on investment of 4.25, so very economic in that regard. The added severance tax at 4.5% is over $270,000. And if we were to drill 20 wells within the lands that we're recommending spacing, that's an equivalent of $5.4 million in additional collected severance taxes. In summary on this slide, the 330 setback allows us the flexibility to optimally space the wells and also protect correlative rights and prevent waste.
And finally, Mr. Pitzer, turning your attention, or not, pardon me, Mr. Porter, turning your attention to what's been marked Exhibit W. If you could please describe what Exhibit W shows.
This is a slide with the blue representing the Castle Peak Formation, the orange, the Uteland Butte Formation, and the Wasatch in pink. And this is just one potential iteration of how the wells might be drilled to accomplish drilling the 20 wells per DSU that we're trying to get approved. It doesn't necessarily depict the exact location of the well, where the well bores might be, but it's a depiction.
Thank you, Mr. Porter. Mr. Porter, in summary, based on your examination of the evidence and the data in support of this request and the exhibits presented, is it your expert opinion as a recognized expert in reservoir engineering that the engineering supports the requested units for long lateral horizontal wells?
Yes.
And Mr. Porter, based on your examination of the evidence and the data in support of this request and the exhibits presented, is it your expert opinion that the data supports the proposed reduced setbacks?
Yes, it would.
And is it your expert opinion that the proposed reduced setbacks would recover resources without adversely affecting correlative rights?
Yes.
And Mr. Atkins, based on your examination of the evidence and the data and the exhibits in support of this request, is it your expert opinion that the proposed drilling unit spacing for internal drilling unit boundary wells is supported and justified to efficiently drain the resource?
Did you ask me or him?
Mr. Atkins, my apologies. That was supposed to be directed to Mr. Porter. Let me restate that question for the record. Mr. Porter, based on your examination of the evidence and the data and exhibits in support of this request, is it your expert opinion that the proposed drilling unit boundary drilling spacing units are supported and justified to efficiently drain the resource?
Yes, they do.
Thank you, Mr. Porter. And with that, Mr. Chairman, that concludes my examination of Mr. Porter.
Thank you. Division, do you have questions of this witness?
I have a question on the economic slide. Actually, I think it was the one before that. I just need a little bit of extra help understanding this. The column for BF, and for AF, those are the increments are feet, correct?
Yes.
Okay. So at about 6 years, you said that it would expand beyond the 100. Well, I'm sorry, I'm confused about this.
Yes, you're right. It would extend beyond the 100 feet setback.
So it will eventually cross lease lines,
Yes.
estimated to happen in about 6 years.
Yes, a little over 6 years.
Okay.
Dane Doucette with the division. So I may have missed it in here, but does your request have any interwell offsets between long lateral horizontal wells or between the long lateral horizontal wells and vertical wells?
I think that might be something that Scott could answer, but to my knowledge, no.
Are you concerned about interference between, say, a long lateral horizontal well on 1,280 acre spacing, interfering with a vertical well that's on a different spacing?
I think more specifically, what I'm more concerned about is potential depletion. That being said, I've not seen, there have been examples in the basin just offsetting this where wells have been drilled in very close proximity to existing vertical wells. And vertical wells did not appear to have any, they were far enough along in their life that they're not adversely affected. And the vertical or the horizontal wells don't even seem to be that materially affected either. So I think what that is suggesting is there's a lot of unrecovered hydrocarbon around those vertical wells that you can access with the horizontal.
Does Finley have a plan for a minimum distance between, say, like a vertical well and a horizontal well? I mean, I guess if you're not worried about interference, if nothing else from a safety intersection standpoint.
Yeah, I don't think we specifically call out a distance, but it would be a safe distance to mechanically drill the well and in a safe way, right? So we're not going to take a risk of intersecting the well with the horizontal well, but we'll be a safe enough distance away in order to achieve that. So that's
okay. Thank you.
That answers your question.
That concludes our questioning. Thank you.
Great, thank you. Division, board members, I will go to Mr. Moon.
Isn't it correct though? You sometimes will skip a frac stage when you're going past a vertical well, or do you still just frac it anyway?
Yes, it is. It's fairly common practice to skip a frac stage potentially, because the last thing you really want to do is get a direct hit on your offset vertical well.
And then on the same slide, we have Exhibit U. You're saying like at 5, 6 years, you may exceed the 100 feet, but at what orientation? Because this shows a more of a 45. If you have a really flat orientation, you're still gonna exceed that 100 feet because you'd have to be reaching out there a long ways to get 100 within 100 foot of the, or to get to the 100-foot
Right.
setback lease line.
Yeah, and that's why actually I'm using 100 feet because it is essentially flat. It's in this, it is the 45 as for
But
illustrated.
it is flat. Okay, so it's really just reaching out naturally
Yes,
against the orientation 100 feet. Okay.
yes,
So you do need the 100-foot cushion. I mean, well, you need, we could argue about what it should be. You need at least 100 feet because you are reaching, even though the orientation is flat, you're still reaching 100 feet
Yes.
over years. And
Right.
so you are recovering that resource.
yes, that's correct.
Okay.
If I can also point out on this slide that it looks like visually it's at a 45-degree angle, but it applies the same orientation of 85 degrees and the distances that we talked about earlier on earlier slides.
Any further questions from the board? Yes, Mr. Church.
This may be a question for Mr. Pitzer, but so on ownership, are you is Findlay the primary owner of the leased minerals from the tribe? Or are there other companies that have leases from the tribes in that land?
There are other companies that have leases from the tribe.
Okay, but in all of these units, Findlay is the majority interest owner.
Let's see, majority. Yes, in the units we have at least half or the majority of each unit.
Okay, so the patented lands to the south and the two special units, are they all leased or are there unleased interests in those?
There could be unleased interest in those.
But the majority you feel are leased.
Yes.
Okay, thank you.
Any other questions? Hearing none. Assume this this ends the Finley's presentation at this point on.
Yes, it does, Mr. Chairman.
Okay. Well, we will turn it over to the division to present their material.
We have a slightly unusual request. May we please take a 5-minute recess to caucus with petitioners?
Sure, that's not unusual. Go ahead.
Okay.
Go off the record.
Thank you.
Never gonna. Yeah, sure.
Currently, we have, speak, one, just in, we literally have 4 concurrent public meetings. We're back on the record.
All right, thank you, Michelle. We'll go back on the record.
Right.
Division, are you ready?
We certainly are ready. Thank you.
Great.
So based on the testimony that's been provided today, in conjunction with the exhibits, the division is generally supportive of the requested relief. However, in consultation with petitioners, we would request a slight modification to the requested relief, assuming that petitioners will stipulate to it, which I understand they will, but I will let them speak for themselves. And that is in the area above the Castle Peak, there's a water flood. And so any horizontal development that would occur in that area would be harmful to correlative rights. And because petitioner only expects to engage in horizontal development below the Castle Peak, we just would prefer that the order specifically identify that horizontal development will occur below the Castle Peak. Castle Peak and below, I guess, is more clear.
Okay. Is that the sum of your discussion?
Yes, it is. Thank you.
Okay, thank you. I guess it's appropriate to ask right now, Finley, if you're prepared to make that stipulation or agree to that stipulation.
Yes, Mr. Chairman, Finley agrees with that stipulation. And if the board approves its request for agency action, we would call out that as an amendment within the proposed order.
Board members, do you have any issue with what's being proposed? Great. Okay. Well, I think then we'll turn it back over to Finley for summation.
Mr. Chairman, if you will allow, Mr. Pitzer has just informed me, he just wanted to clarify a response to Mr. Church's question earlier.
Yeah, Mr. Church, you'd asked me about the lands to the south that weren't tribal. And I just wanted to clarify that some of the lands are leased, some of the lands aren't, but everyone, if it's not leased, they're notified. So just wanted to clarify that.
Okay, thank you for that clarification.
Thank you, Mr. Chairman. And I believe, yes, one housekeeping item, I did want to move for admission of all of our exhibits now that we've concluded our presentation. And in summary, Finley respectfully requests that the board grant the relief as requested within its request for agency action and as amended pursuant to the stipulation during this hearing today. As the evidence demonstrates, granting the request is in furtherance of public policies of the state of Utah to promote greater recovery of oil, gas, and associated hydrocarbons without waste and with protection of correlative rights of all affected owners, and constitutes orderly and consistent development and is just and reasonable under the circumstances. We again therefore respectfully request that the request for agency action be granted as amended pursuant to the stipulation today.
Thank you. I just, as a point of clarification, you're asking us to admit exhibits A through W.
Yes, that is correct.
And then
Chairman Hansen.
there was a mention that on exhibits O and P that there was a correction that should have been made on Garden Gulch versus TRG3 or no, I'm sorry, TGR3.
Yes, Chairman Hansen. On both exhibits O and P, the Garden Gulch should be replaced with sorry if you mind.
TGR3. Yes.
Just wanted to make sure I say that correctly.
I'm sorry, I kind of led you down the path on that one.
No problem, Chairman.
The question I would have then is, do you want to submit corrected exhibits or just make administrative note that that verbally during the hearing that it was corrected in the record?
Happy to do whatever the board would prefer us to do, Mr. Chairman.
I think I hate for you guys to have to spend more time, but to make as perfect a record as possible, I think it would be appropriate to submit corrected exhibits, if that's okay.
Certainly, we're happy to do that.
All right. At this point, I think that it's appropriate for the board to make a determination as to how we want to act on their request for agency action. Does the board want to deliberate, or do you feel like you've heard enough and you have an opinion that you would like to vote on?
I'd like to ask one question, clarification.
Sure.
Just for a second, but yeah, I'm in support of it.
Okay. On this exhibit, Exhibit U, I'm not familiar with what Hales and Evers dealt with there, but when you're coming up with your interpolation there to come up with 6 years, are they actually saying that fluids are crossing the line, or just the pressure wave is coming across? Because you mentioned you were doing transient analysis there.
Right. Technically, I think it's saying that the pressure transient, it's not necessarily fluids, but
Okay.
you could infer fluids potentially.
Well, at that permeability, I don't think anything's moving, but
Not very far.
okay. Thank you.
So I'd be willing to make a motion unless we want to deliberate.
Any desire to deliberate, or have we made our, okay? Well,
Okay, I move that we accept this request or approve this request for agency action as amended.
Is there a second?
I'll second that motion.
Discussion on the motion? Hearing none, we'll take a vote. All those in favor say aye.
Aye.
Any opposed? Hearing none, the motion is passed unanimously. I would expect that you'll prepare the order.
Yes, Mr. Chairman. And I just want to take the opportunity to thank the board on behalf of myself and our witnesses in Findlay. Thank you very much for your consideration. Thank you to the division for its cooperation, the board staff, technical staff. We appreciate your time. Thank you very much.
So why Findlay, not you and a wax?
This is Findlay operated lands, and I also do some work for UNOWAX on UNOWAX operated lands. So
okay, I thought it was all not combined then. Okay, all right.
Well, thank you for your presentation. Division, thank you. And I think that was the last matter before the board, so we can entertain a motion to adjourn. There's no vote required. We will adjourn. We're off the record. Thanks, Michelle.